It is family dispute, sir, theft of a fish in a pond, my lord. So thereafter the informant lodge affair.
What do you want?
Tomorrow, my lord,
Not tomorrow. Give your memo, we'll see.
ଦେଇଥିଲି sir
Not tomorrow.
Decided with some review petition 2008 matter. It was specifically.
Give the memos, we'll check. Give the memos, we are trying to adjust all the matter. According to the.
Single bench matter, judge has retired.
Yes.
challenging the and
Modification of order. Order relating to, my lord, the case is pending in the court of law and district judge and special court. Inadvertently, I have mentioned in prior portion that the case is pending in the court of law and.
Then you have to amend your
Then I have committed mistake.
So amend your petition, not the order. Unless you amend the petition.
The order has already been passed, my lord.
I understand it because you have written inadvertently in the prayer clause. In the order it might have come. So the prayer clause you have to be amended. Application is appropriately to be moved. Okay.
My lord, another is the order of a cognizance is under the.
Give
This
this.
is the matter of the year 2024.
Give the 24 fresh matter.
Fresh matter.
How it is not listed?
It was listed. But your lordship was pleased to direct the state council to obtain instruction.
Okay, then we'll see. But all the fresh matters have already been listed once.
Oh, so.
Let's see, yes.
Sorry.
NBW challenging the NBW your lordship.
NBW, yes. NBW.
Modification of order, my lord.
Quashing the proceeding, my lord.
1 minute. What modification, sir?
Directed to appear before the police station once in a week. Petitioner belongs to outside and he is appearing in the court date and also in the police station. My lord. Two matter, my lord.
देखी लोगे तो modification.
Quashing the proceeding, my lord. OP has.
Then you want to, you're planning to abscond.
My lord.
You are planning to abscond.
No, I am appearing, my lord, after release on bail. खाली police station appearing.
देखिए देवे तो नहीं modification has to come to this court only.
Modification, this court order.
Okay. Modification will come at this court
This court.
or Asian bench. Okay.
Quashing the proceeding, my lord. OP has appeared and filed affidavit. Let it come next week. Matter was fixed to
What are the offences?
294, 323, 448.
देख नहीं जाओ देखिए रे okay तो
Vigilance matter, my lord, for hearing, my lord. When the petitioner health condition is.
you can't give relief on all the matters. You mention it tomorrow.
2014 matter, my lord.
14
14,
AP
my lord. My lord.
weekly. Yes, any mention?
Lordship, pardon to mention, my lord.
Yes.
Lordship, item number 62 may be taken day after tomorrow, my lord.
We'll call. Wait. Yes.
They mention item 1 to 8.
My lord, item number 8. Can you take this matter next week?
3,
8, my lord.
8. Yes.
My lordship, item number 5 can be taken up next week.
Adjourned. Okay. So, June, huh? June. Yes.
Item 9 to 21.
Item 11 next week.
I may be pardoned, your lordship. Item 9. I place an adjournment, your lordship. On behalf of Mr. Parijat.
My lord, item 15 and 16. Lord.
1 minute. 9, huh?
Yes, your lordship, item 9.
June. 11?
Next week.
Not next week. Everything will go to June. Don't ask. Whatever. Yes.
My lord, item 15 and 16. My lord,
15?
15 and 16.
Yes.
Lordship, can I adjourn to next week?
15 and 16, na? June, huh? June. Not before June.
22 to 36.
Lordship, item 26. Pray for adjournment, lordship.
26.
Item 30.
30.
20?
30.
1 minute. 30. June 32? Yes. Again 32.
37 to 49.
26 allowed.
50 to 57. 58 to 66.
66, my lord. 506 of compromise be. Like,
I'll take it up.
then see, again, the cover paper.
What are the offenses?
506.
Uh,
Police gala kitchen I going chadi dala.
Bring them at 2 o'clock. I'll finish it up.
Aaj se nahanti.
Very- Saturday. Fifth. 11 see everything. I am following a system. So let it be on 5th. That is a Saturday. So that's a whole working day, na? That's a working day immediately. Therefore, I'm saying.
Lord, item 59, on behalf of Mr. Mahanti, his father is expired.
59.
My lord, one chapter,
What happened?
one chapter.
Is there any problem?
My lord, his father is expired.
There is a bill. Yes.
Item number 62, my lord.
Yes.
Lordship, this matter may be taken upcoming week, my lord.
Huh?
This matter may be taken in the next week, my lord.
It will go to June, sir. June.
Sorry, my lord. This is the compromise matter, my lord. The victim is unable to present today.
No,
But
service
the-
is also not complete after 4 weeks. You have not taken steps. Yes.
67 to 73. 74 to 83.
My lord, 70-80 can be taken in next week.
78. Around request.
Lordship, 75 may be taken up next week.
75 also. Mediation, what happened to mediation?
The mediation failed.
Failed. Please,
It was the next week.
75, yes.
84 to 91.
I have a small matter, my lord, of case of 2020, CRLMC.
Which one? Which item?
No, my lord, I want to mention to list the matter. 494 is the alleged offense, and the petitioner is a lady who is a government teacher. I taken up next week, NBW is put in the lower court, my lord.
NWL, I'll see, don't worry. Yes. Yes.
My lord, CRLMC for case admission, my.
It is a murder case, I am for the informant. The stay has been made and case of 2022.
It will come.
CRLMC for case admission, my. Let it be listed next week.
Keep the note. Yes.
Item 1.
Sir, may
Yes.
Notice was solved. Subsequently, Lordship directed, I extra copy also served to the State Council.
Opposite party number 2.
Yes.
Service.
Notice registry posted Ikram law.
This-
Thereafter, Lordship last occasion directed to serve extra copy so that it can be solved by the IAC concerned.
Take it up.
We have not received the report with regard to service. We have sent the letter. Lordship gives another chance.
Through IO, huh?
Oh, yes, on 6th
Notice
March,
was-
we have sent.
By the order dated 4/3/2025, notice was directed to serve to opposite party number 2 through the IO of the case. Although the notice has been forwarded to the IO, but no certain has yet been received by the State Council. He seeks an adjournment in that regard. Please the matter. Yes.
Well, interim order to
Interim order.
Item 2.
Meet page Lordship. The present petition has been filed by the petitioners seeking quashing of the order dated 9/1/2023, wherein the learned court SDGM passed an interim order of compensation without citing any reasons thereof. My lords, the interim order is at Annex 4.
What are you challenging them?
My lords, the order of
9/1/2023. Where is that order?
Annex 4, page 23, Your Lordship.
Yes. Yes.
without citing any reasons thereof, the learned court has passed an interim order of compensation of paying 20% of the amount. Without considering my contention, I have filed an objection to the petition stating my financial inability to do the same.
The reasoning is written, it's well written in order.
No, Your Lordship,
What else you need?
it has not been mentioned specifically. Reasons have
What,
not.
whatever you want that has to be written or the court
My
wants.
contention has also not.
The reasoning doesn't mean that whatever you want that should be there.
Your Lordship, the
The
relevant.
reasoning is that just see 3 pages, single space.
Only the judgments have been cited, Your Lordship. No reasons particular is.
Check amount, check amount.
Check amount is 10 lakhs
22,000.
20%. For every 143A matter you're coming
Statute
to.
provides,
Huh?
madam. Statute provides.
The
madam.
discretionary power, Your Lordship, but
Will you settle with this food?
so I have to take instruction.
Not instruction. Will you settle? Then I'll interfere. Subject to you paying 10%, I'll send it to mediation.
I'll take instruction. It may be passed over.
Pass over. 10% you deposit, I'll send it to mediation and explore the possibility. Okay?
Okay.
Item 3.
This is a matter where Your Lordship has directed me to go through the recent judgment Your Lordship delivered in respect of the 376 case where compromise has been arrived, and Your Lordship has distinguished this
See, POXO.
POXO. And out of the wedlock there is a child also, and Your Lordship may see, or Your Lordship.
What is the age of this boy?
Now, boy is
23.
Is now it is 17 years. The girl is 17 years. For that reason,
Yes, what do you say?
Due to adjournment, is at the age of 17.
Have you read my judgment? I distinguish that.
ସେଇଥିପାଇଁ ମତେ କହିଥିଲେ last occasion ଦେଖିବା ପାଇଁ.
Have you gone through? Please go through. I'll just pass it over.
Yes.
You go through. I distinguish that Ramji Lal.
Yes.
The Ramji Lal judgment.
Just I'm going
I
to-
requested
Yes.
Mr. Bose to assist me, but by the time the judgment came, and he said that it's he has
covered
covered everything.
Yes.
I had requested him to.
Paragraph 6, 7, 8, Your Lordship has covered
Rosamond
everything.
judgment was on one part. In this part, your lordship has,
Added that and
Yes.
distinguished.
your Ramji Lal judgment, your lordship has.
Just check it up, huh? And keep this judgment, because wherever they are covered by this judgment, we'll allow.
Yes, yes.
Why to, you know,
More sub. ସେମାନେ affidavit ବି ଦେଇଛନ୍ତି, they are staying jointly.
whether they have come here.
No, Your Lordship has once called. Your Lordship has
Then you call, and by the time he'll read the judgment. When do you want to tell me?
I will intimate him because
When you tell me the date.
next week any date I
Saturday, 5th.
Fifth.
By the time he'll read the judgment of
Yes, yes.
5th. Okay.
8 and 9.
Yes. Yes.
Item 4.
Interim order में
Interim order to country.
Item 4.
Pass over.
Item 6.
My lord. Your lordship may kindly see the order dated 2/7/2024.
Page.
Order.
Yes. Yes.
ଆପଣଙ୍କୁ training ନେଇନା। Two seven twenty.
Yes, charge sheet is now filed.
Yes, charge sheet has been filed against me when I am not the owner of the vehicle.
But see, the owner of the vehicle is Nirakar Sahu.
Yes.
Nirakar Sahu has said that I had given to the petitioner.
Correct. But once the ownership is not transferred, mere by an agreement, can a immovable property be transferred, my lord? Then section 17B of the...
No, that's not the case. Case is whether you have employed this car for the purpose of commission of the...
My lord, I have never employed. He had given me the car, but due to this...
Case is it was registered in the name of Nirakar Sahu.
Yes.
Nirakar Sahu says that I have given it to the petitioner. You.
Yes.
And you might have utilized that for the purpose of
but
carrying.
It will not be added as party. I may be added. How will I be added as a party? How will I be charge sheeted, my lord?
I don't know what are the materials.
Yes. How I will be charged?
What are the materials?
Temporary possession.
Huh?
It's temporary possession.
No. What are the materials you have? The story goes correctly. No problem. Have you got any material? Nirakar Sahu statement have you recorded?
They have not recorded Nirakar Sahu statement because I have got.
Has Nirakar Sahu said that yes, I had given the car to this petitioner?
That has to be ascertained.
Without that, how will you implicate him?
This is the
verified.
Yes.
And get the charge sheet, huh? CD.
No, charge sheet, my lord, I have annexed the charge sheet.
No, all 161 statement you have read, particularly Nirakar Sahu.
Yes.
Right. The charge sheet is the
And if your lordship may permit, I will produce that RC book also.
Subsequent to the order dated 2/7/2024, charge sheet has been filed in the
My charge sheet is at page 24.
No, page date
24/11/2022. Charge sheet filed.
22.
Last page of my lord's brief at page 37.
22.
My lord, yes, 24/11/22. Charge sheet has been filed.
22. 24/11/22. 24/11/2022. Charge sheet has been filed. I have filed. The coordinated bench of this court on 2/7/2024 has directed the state council to ascertain the material form part of the charge sheet against the petitioner. The council for the state seeks an adjournment to verify the material, release the matter after 4 or 5 weeks, and the interim order shall continue.
My lord, with your lordship's permission, may I add 2 lines? My lord had permitted me to appear before the investigating officer. I had appeared, and I had placed all the materials on record before the investigating officer. That was on.
No, the problem is this.
7/24.
Was it open for reinvestigation?
No.
Then what? By the time the order was passed by the coordinate bench, that time the charge sheet was already filed.
Yes.
What the investigation officer will do?
No, I had placed the original documents.
No, it says that the opportunity is given, he'll explain. Explain to whom?
There is no scope.
But
what kind? How will you get the judge the order? Explain to whom?
My lord,
that is the reason I thought that charge sheet is not filed.
No.
Reading that order.
But my lord, I had to comply your lordship's order. I appeared. I placed all the materials.
Before whom?
Before the investigating officer, Inspector Aurora Police Station.
What will he do? He has filed.
No, he could have taken the statement of Nirakar Sahu, because my instruction is Nirakar Sahu statement has not been recorded.
He can file a supplementary charge sheet or something of that sort.
Yes.
What have you done? Because the court says, the coordinate bench says, that he will go and explain to the IO. Even if he is explaining to the IO, what will the IO do? Unless there is a direction that file a supplementary charge sheet.
Evidence to be laid before the trial. Now the charge sheet has been submitted. Our statement is there.
But see, this order, when this order was passed, you were there.
Yes.
Today you can't wriggle out of this order. How will you get out of this order? The order dated 2/7/2024 passed by the coordinate bench has not yet been complied.
No, I have complied.
You have complied, but yes.
Item 7.
This order is very innocuous now. You should have pointed out. Charge sheet is filed. What the IO can do? Nothing. Once charge sheet is filed, he is sanctus officio. Completely sanctus officio.
In fact, the date was.
Once he is a sanctus officio, any direction is made, what can he do?
Okay.
Even if he will come to the conclusion that he is innocent, he has no role to play now. If 173(8) is open, then I can understand. It is not
open.
And you should have said that you open it. Why don't you do one thing? You pursuant to the order dated 2/7/24, you move an application for further investigation. It has to be complied. Somebody should move application. I will not say. I will. One order I can't add further.
I will take my.
At least the IO should have moved the application.
Yes.
Saying that in pursuant to the High Court direction, now you have give me opportunity to file further evidence. You should do, you advise your client.
In fact, my lord, this.
IO should move application pursuant to the order of the High Court. You allow me to place on record the further evidence. Because he has supplied further evidence to you. You have to place it on record. Move application. Shall I record it?
I'm not right.
Do whatever. But now you are in difficult position after that order. Or challenge that order, whatever you want to do. Yes.
Well, what is there to be challenged, Mal?
That's their outlook. Yes.
Grateful.
Item 7, my lords, on behalf of Mr. Mohan, item 7, my learned friend has filed some additional documents at flag B, my lords. May I pray for a spare copy, my lords?
Give a spare copy. Mr. Marana is not well. Adjournment.
Next week, my lords. There's an interim.
Interim. Yes.
Great.
Item 10.
Yes. Pass over.
Item 12.
Yes, sir. May I please, your lords? I am appearing for the petitioner, my lord, along with Mr. Bodhi.
The petitioner.
My lord?
You are for petitioner?
Yes, your lord.
Yes.
The petitioner is the complainant in the 138 proceeding.
Yes.
He had sold a property to the opposite party, your lords. The opposite parties, he had issued a check for 5 lakhs. Sale deed was executed. On being deposited, the said check returned unpaid. Consequent upon which I filed the 138. In 138, my evidence is closed. And she did not reply to my legal notice, that mandatory 138 notice. There was no reply to it. That she has admitted in deposition also, that will take your lordship to that if required. Now, question is, at the time of defense evidence, what she does, she comes up with 2 documents perpetually executed by both of us. That in lieu of the check, she has already received in cash. I'm clear, my lord.
Where is that? And that is taken on record.
That is taken on record. My application, because now it requires, I should clarify my stand. That's why I filed an application to recall myself, 311. That came to be rejected, for which I am before my lords.
Well, issue notice.
Proceeding is fixed to 25th.
Stay, because the complainant, he is complainant.
Yes, yes.
See, now he has a rebuttable, the presumption operates against him, and rebuttal he has placed on record some document. Then he has to get an opportunity to,
He has already got the opportunity.
Where is that order?
Page 37. Rejected.
Reject. He moved the application which has been rejected. That's right. Petition is agreed by the order dated 28/11/2024, whereby his application under section 311 CRPC to recall PW1 for examination only for clarification about the exhibit D1 brought on record by the opposite party
under objection. That is
objection has been turned down. The petitioner is the complainant in the present case. Issue notice to opposite party, that will also. And in the meantime, the trial, the proceeding before SDGM Sadar Katak in IC 1CC case number 533 of 208 2018 is stayed. Yes.
13,
Yes.
Pass over.
Pass over.
14,
Pass over. 13, you are there? Okay. Yes, 13.
Your Lordship, last occasion, Your Lordship called for status report.
We have not received, we have sent it.
Pursuant to the order dated 3/8/2025, the status report has not yet been received by the State Council, hence he seeks an adjournment. Please the matter. Yes.
14,
Lordship, date be fixed.
Yes, Mr.
This application arises out of 125 proceedings. Interim maintenance has been awarded.
Yes.
That was assessed before the regional court, which stood confirmed. Now both the orders are challenged in this proceeding.
Yes.
Here the limited question is that only on the basis of the 125 application, without assessing the income, the interim maintenance has been awarded. It is for your Lordship's kind appreciation. I draw your Lordship's attention to page.
Where is that order, impugned order?
Impugned order, my lord.
29.
Page
Annexure 6.
31.
Annexure 6. huh?
Yes.
What is the
The failure
amount?
to file the affidavit, this was also one of the ground. The court affidavit in terms of Rajnish and Neha.
Yes.
The court said, in fact, in certain cases applying discretion, the award can be made. There is no dispute about that at all. But where the income as alleged by the petitioner or the application who was filed is completely denied and disputed, the Honorable Court below would have been slow in granting, and that too without assessing the.
What are you doing for living?
My lord, presently I'm not doing. Page annexure 7 maybe see.
It's only 4,000 rupees.
No, only 4,000. Even page annexure 7, page 44 may be seen. What is my condition?
Yeah.
44 and 45. 61 year.
Whatever you are able person, your wife has how the wife will survive?
At least looking at this, my lord, your lordship. I think your lordship. It's my.
What is the age of your age?
61. She is 36. But see the condition now.
Second marriage.
Second marriage.
You have the luxury of marrying at this age. This is bound to happen. You have to maintain your wife.
Your lordship, for a moment, see.
I know I have seen it, but what to do? The second marriage, she is 36. You are 65. You
No,
have
not
the
65, 61.
61. So then what to do now? Okay, I'll issue notice. Issue notice.
Completely handicapped presently. 44, 45.
What to do? But she has a right, legal right. 4,000 is very meager amount. Very, very meager amount. What are you doing? You are a retired person.
No. I was having a fast food shop. Presently, because of this severe burn injury and because of spine, not in even work.
What happened to your first wife?
First wife, my lord, died. Thereafter.
How many children?
No issue. No issue.
4,000, how can what?
It may be sound like severe attribution. Even against the wife, there is a case of killing the mother-in-law. May not be relevant.
Anyway,
your lordship can visualize.
Let us see if anything can be done. Let her come.
Yes.
Okay.
Item 17.
Only thing your lordship can say, so no proceed. At any moment, he may be arrested, my lord.
Oh, how can he have, where is the execution petition?
Education, not.
Then, once the execution petition file, you come.
I'll take the.
Yes. Yes.
Lord, item 17, on the ground of compromise, my lord, I filed this application. As the brother-in-law of the informant was died yesterday. May I pray on Friday, my lord, because of both the parties are ready to come before this court.
I'll give a little later date. Brother-in-law of
Informant. The parties are ready.
The consultant petition submits that the brother-in-law of the informant has passed away yesterday, and she is not able to appear before the court, and she is in adjournment after 2-3 weeks there.
Friday, my lordship, may say. Coming Friday.
Not Friday, we'll see. Yes.
Item 18.
Pass over.
Because SCST is there, notice to go. The lordship may issue notice, I will file
Issue notice also. Issue notice. Yes.
19.
You put a letter, issue notice. Issue notice. Yes. 19.
Item 19.
My lord. Item 19, my lord, NBW issue against the petitioner on 10 December 2024.
10 December
2024.
Yes.
And my lord, the case was committed to court of session and trial is going on, my lord.
500. 500. Who did the report? Yes. NBW. Yes.
20.
Pass over 20. Okay.
21.
My senior Vijaypura is out of session due to bereavement in his family. Pray for next week.
Who is your senior?
Vijay Kumpar.
On behalf of the counsel for the petitioner, and the adjournment is sought on the ground that there is a very in the family. After 2 weeks.
22.
On behalf of Mr. Alok Kumar Panda, Amala can be taken next week. On behalf of Alok Kumar Panda, Amala can be taken next week.
22.
My lord.
What happened?
Can you take it next week, my lord?
Not next week, it will go to June.
My lord.
On behalf of the counsel for the petitioner, Alok Kumar Panda, I request for adjournment, leave the matter after 6 weeks.
23.
Twenty-three.
Quashing of the affair, offense 341, 294, 324, 506 on the grounds amicable settlement and there is civil dispute. That aberment has been taken.
Okay.
In the
Pass over.
24.
May I please, Your Lord? Initially, case was registered against the petitioner 306, my lord. After proper investigation, final form was submitted. There is no is a false case. FRTA. Thereafter, a protest petition was filed, my lord. In that, inquiry was
cognizance is taken.
Cognizance was taken.
306. Show me the protest petition.
protest petition, there is an annex.
An initial statement.
Neither my protest petition, not
that your file.
Inquiry, not next.
Next week, as soon file
on the. Have you implemented opposite party? Protest petition, you have not implemented opposite party also.
এটা cost title file করতে হবে এটা দিয়ে দেবে
you do simply I'm adjourning it up to
yes.
2 weeks 2 weeks you are
next week
it is arising out of protest petition you have to implement informant I would have issued notice today itself. Yes. Simply after 2 weeks
25.
Mr. Sahul and counsel for the petitioner seeks an adjournment to amend the memo of parties and place on record additional release the matter after 2 weeks. Yes.
I will pardon my lord. Item 4 multi cancelled for you.
For pass over.
Matrimonial dispute. there is a, your lordship sent for mediation after 34 years of marriage, my lord. FIR has been lost against husband after retirement. Lordship sent for
498A.
yes, my lord.
Oh, notice करो 498. Item 4 notice करो.
Mediation को आगे पठेई दियंतु.
Notice करो short date दूची 2 weeks.
आगे.
सब करंतु तापर mediation पठाई. ठीक है. 4 notice कर दिया.
Yes.
You implicate in this matter.
Yes, my lord.
Yes.
25.
May I plead, O lords? I am challenging order dated, my lord, 16/9/2021, my lord. In this case, my lord, initially FIR was lodged under section 376 along with the other offence, my lord. In the meantime, my lord.
This order 16/9.
What happened? Charge sheet has been filed against the present petitioner in excluding 376, but the London trial court has taken cognizance, including 376. That is under challenge.
Yes, my lord.
Yes.
So I am the mother and brother, my lord.
Against you also 376 seconds.
Yes, my lord.
That is under challenge.
Accused person. 34 is there. 34 is there. Yes. Show me the.
The charge sheet is page 26, relevant page is kindly glance 26.
What is your name? Your name is Sagar Swami
And Radha Swami.
Let us see what are the allegations. Yes.
In petition, page 26.
Yes.
In petition of this case, disclosed that the victim Kajal Swami is the younger daughter of Bhagi Swami. Her father Bhagi Swami had blessed with 4 daughters, namely Puspa Swami, Kajal Swami, Dutti Swami, Asa Swami, and 1 son, namely Sibo Swami. The victim Kajal Swami was reading in class 10th in Tintulia High School. Since last 5 years, the love relationship developed in between the victim Kajal Swami and accused Jagar Swami. Gradually, the accused Jagar Swami kept physical.
Anybody appealing?
Yes, not for the opposite party, for the petitioner, your lordship.
I'll just issue notice.
Lordship.
Okay, issue notice.
30.
Your mind, the limited prayer of the petitioner is that a case, my lord, which was registered in Advocate as 2018, charge sheet was laid in 2020. Since September 2020, my lord, there is no progress, and the case has
early disposal of the case.
Early expeditious disposal of the case is the limited.
What are the offences?
420, 422, 406.
Show me the proceeding, whether you have delayed or who is delayed.
My lord, I am for the informant.
Huh?
State, my lord, state is the proper party. I am for the at the instance of
Informant. You are
Yes,
for
your
informant. Okay. You are for informant.
Since September 2020, my lord, charge sheet has been filed. Cognizance has
Informant in Chaudiaganj PS case number 135 of 2018. 2018. What's up? At his instance, the FIR is registered for a least commission of offences punishable under section 420, 422, 120B, 406, and 34 IPC. After investigation, charge sheet has been filed on to Kudiye, to the Kudiye. Then Congress for the petitioner submits that despite the fact that the charge sheet has already been filed about more than 4 years back, but the trial has not proceeded up to today. Hence, he is aggrieved and seeking indulgence of his court for a direction for expeditious disposal of the trial. Disposal of the trial. Regarding head to the amendments made in the application, and the fact that the charge sheet has already been filed 4 years back. The prayer made by the petitioner seems to be innocent and deserves merit. Therefore, the trial court is directed to see that the trial possible. Charge has not been framed.
Yes, my lord, no charge has been framed. They have not yet appeared even, my lord.
Charges have also not been framed. Trial court should do well to see that the trial proceeded expeditiously. Yes.
31.
31 is the matrimonial dispute.
Yes.
The case of 498A, my lord, petitioner. Number one is the husband and others are in-laws.
Yes.
My lord, dependency of this investigation, my lord, the victim, they filed a divorce case also. And divorce has also been allowed by under Annexure 4, my lord, see page 32.
Issue notice. Issue notice, the petitioner is the husband of opposite.
Petitioner number one is the husband,
one is
two, 3 are in-laws.
petitioner number 1 is the husband of opposite party number 2, whereas the petitioner number 2 and 3 are the in-laws. At the instance of opposite party number 2, the FIR Hon'Ble PS case number 202 of 2022 has been registered against the petitioners. After investigation, charge sheet has been filed in the present case on 3/6/2022 for alleged commission of offences punishable under section 323, 506, and 494, 498 capital A, 34, read with section 4 of DPF. Mr. Dhalder and counsel for the petitioner submits that the petitioner number 1 and opposite party number 2, the marriage between the petitioner number 1 and opposite party number 2 has already been dissolved by judgment of by judgment dated 26/12/2023 passed by the family judge Hon'Ble in CP number 23 of 2022. Issue notice to opposite party number 2 written form. In the meantime, proceeding before form so it's state. Yes.
53.
Only my lord, it's to issue notice.
Yes.
Stay.
Stay I granted. Stay. Divorce has already been granted.
My lord.
Then what else?
33.
The case of the section 20B 2C NDPS Act. 120 kg ganja recovered from the petitioner.
What is he asking? Quashing.
Therefore, to quash the criminal proceeding, entire criminal.
Yes.
34.
May I please, my lord? My lord, this case relates to applicability of OPID Act from retrospective effect as well as in the field of real estate transactions, my lord. This honorable court pleases to hold that this act cannot be allowed to hold in the act in the field of real estate transactions, my lord. The same has been challenged by this state, and today all the matters along with other matters were listed before the Honorable Apex Court, Court number 15. I humbly pray that this matter may kindly be adjourned for some day because I want to take advantage.
There are two judgments of this court.
My lord.
One judgment says that section 6 doesn't attract in this because there are not
Yes,
financial.
all the matters are there.
The other matter, the court says that that judgment is per incuriam.
Yes, my lord.
Where is that judgment per incuriam?
That my lord.
This is R.K. Patnaik judge.
No, my lord. That my lord.
There is a judgment which says.
Yes, my lord. Because around 8 numbers of matter listed today, my lord. So, my lord, I humbly pray for an adjournment.
Simply adjournment after 2 weeks.
Okay.
No, let the counsel for the petitioner submit that the issue in this present petition is subject matter of a batch of petition pending before the Supreme Court. Today the matters are listed before the Supreme Court and petition adjournment. Please take matter after 2 weeks. Yes.
Obliged.
35.
May I please? In this case, I'm informed. Application challenging for quashing of FIR. Offense under section 294, 557, 354, 354B, 395, 506, and 34 of IPS under duty section 25, 27 of RMAX. My lord, in this case, the FIR was lodged due to the political rival. And in the FIR, the petitioners have no specific role against the petitioner.
Yes.
Joint affidavit joint affidavit
My lord, in this case, I am informant, my lord. Both are compromised each other.
Where are they?
My lord,
Where are the parties?
parties,
yes.
Promida, Nisa.
Bring the parties. See the, what are the allegations?
No, my lord.
Date.
No means they will not come.
Asin,
Then let them come whenever. See, allegations are very minor. What are the allegations? Let us see, read it. How many accused are total? How many accused are there total?
Forcibly entered into the.
Page
act
number
of the
14, man. Page number 14.
How many accused, total accused?
Total accused,
Total
my lord,
accused 20.
20. No, 22.
21.
22.
22.
22. Cognizance is taken.
Yes, ma'am. Charge sheet has been filed.
Where you have not placed on record anything. Place on record. Let us an adjournment to place on record the additional document to substantiate the case. Release the matter after 3 weeks. Let him file. Let him file the documents. Yes.
36.
You file everything. How many witness? See, there are 20 accused person. Charge sheet is filed against how many? You don't know. And if 4 of you or 5 of you have come, he has settled with only these 5 people, or what about the others?
ଏଇ ତାଙ୍କ ଘର ପାଖର ଅଲଗା ଲୋକମାନେ
I have no clue. Just your
same neighbor, my lord.
But how many accused are there? How can you partly compromise, partly not compromise?
Three accused.
You people have no idea what you are doing. That's the problem.
Sir, ଗୋଟେ party ଆସିବ ଗୋଟେ date fix.
No. You first file the documents. Let me understand how many accused are there. What is the stage? Nothing is written. File the documents. Yes.
So date fix file कर दो.
Next step.
36.
Imbue has been issued on 12/4/2024, Lordship. And the petition is released on bail, page 30, Lordship. Charge sheet has been Belgium matter.
Belgium, okay.
Yes, Lordship. And anti-petition got anticipatory bail. Thereafter, in first appearance, the warrant has been issued. Imbue has been issued. And
Tell me when you got the anticipatory bail.
Charge sheet has page 13, Lordship. It has charge sheet.
Tell me the dates are when you got
bail file.
24 in 2016, Lordship. 24/9/2016.
24/9/2016, 12/4/2024, 500. Yes.
37.
Miller, the case is filed to quash the entire criminal proceeding as the matter has amicable settled between the parties. Your Lordship may kindly say earlier one application has been filed under section 482 CRPC, and your Lordship order, your Lordship may kindly see annexure 44, annexure page 44, annexure 4, my lord.
Yes.
Annexure, yes, my lord. Annexure 5, my lord. Kindly see, your Lordship directed to the petitioner to move before the appellant court. The appellate court refused the grant the relief. Your Lordship may kindly see quash the entire proceeding as of lack of jurisdictions. Your Lord may kindly see the order. Annexure 6, page 48.
Relevant post.
As the matter, yes. The appeal is pending. Conviction under section 307 years, 7 years. In the meantime, matter has amicable settled between the parties. Your Lordship may the apex court judgment, your Lordship may see. Your Lordship, you will know. In the case of Ram Gopal and another versus state of Madhya Pradesh.
Sir, Ram Gopal is under
Yes,
Article 142.
Yes, ma'am.
Whether have you have any judgment?
Yes, ma'am.
After you being convicted under 307, appeal is pending. You can invoke 482 at CK Quashing, irrespective of the fact that the appeal is pending. Show me any judgment. Ram Gopal will not help you. Ram
So
Gopal,
far as
Ram Gopal is at the appeal, the SLP stage where the court has invoked Article 1 constitutional power under Article 40.
Your Lordship may kindly see in that judgment. Your Lordship may
So
kindly have a glance.
Paragraph 19. So, yes, give that. Do you have another copy?
I have not only one copy. Your Lordship,
Why have you reduced out?
I on behalf of the Bharat Jali, I argue this matter. Affidavit also annexure 4 million. Compromise affidavit.
Let us see the injury.
Yes, my lord. The affair, my lord, on law. Affair.
Show me the injuries.
Injury, my lord. Injury on the belly, my lord. And so far as the charge sheet is concerned, that has not been mentioned in.
Yes, show me the.
इनको चालना करी तली पेटी बेली को
So, where are the evidence? There is a caveat here in the judgment. Have you read it?
Yes.
What is the caveat?
Your Lordship may kindly taken up next week.
No, what is the caveat? You tell me. Have you read the judgment?
Yes, only.
What are the caveats?
As the 307 is there, my lord.
What are the caveats? You tell me in the judgment. When can this judgment can be applied? What are the caveats? Have you read the judgment?
No, I have not entire gone through the judgment. Only.
You have one copy. You kept it for yourself.
You'll also keep it next week. I will.
And that also you would have not read it. See the caveats. And accordingly file the documents.
Yes.
Yes. Let us counsel for the petitioner. Seeks an adjournment to file additional document.
No, that may be.
That is filed after 3 weeks. Yes.
38.
File the additional documents also.
Yes.
To satisfy the key.
That observation. my lord.
38 minutes, I pray for 1 week one week adjournment.
Adjournment.
38.
Seeking an adjournment.
Yes, ma'am.
On behalf of?
Mr. Manoj Kumar Pati.
On behalf of the Mr. Manoj Kumar Pati, and counsel for the petitioners, and adjournment is sought. Release the matter after 6 weeks.
39.
Okay.
My lords, order taking cognizance under challenge, my lords. Cognizance is taken on the basis of a protest petition, my lords. Annexure 2, page 20 is the closure report, my lords. That is final report, mistake of fact. It further reveals that due to some monetary transaction, my lords, that the husband of the OP, my lords, he was ill and she asked for some monetary help from the petitioner.
Let us come to the protest petition. What are the allegations?
And further, my lords, that investigation reveals that the petitioner Alip Kumar Das is my lords, middle caste person being a contrary, my lords. That is also revealed from the annexure 5 is also that the caste certificate, my lords. And cognizance is taken under SC/ST and other offences, my lords.
Yes. Yes, let us see. Protest petition. What are the allegations? Where is the initial statement?
Initial statement I have not
Yeah, that is very
Yes,
essential.
yes, my lords. Yes, my lords.
Cognizance is taken under protest
My lords.
petition. Both the things has to be
I
seen whether
should have.
case
I
is made out or not.
Yes, my lord. Rightly, I should have, my lords.
That comes for the petitioner.
Notice the
An adjournment to.
in the meantime, notice my.
Adjournment to file the initial statement recorded. Initial statement recorded in the protest petition. In protest petition being in protest petition. Issue notice to the opposite party. Lease the matter.
Number 2.
Opposite party number 2 lease the matter. You have a good case insofar as the petition number 1 is concerned.
Rightly, my lords, right.
Why have you included both of them?
Sometimes wrongly, my lords, they are coming under your lordship.
Because petitioner himself is a scheduled
My
caste.
lords. That is what I have.
And another one is Panigrahi.
My lords. Yes, my lords. Lordship was rightly pointed out.
Why are you doing it?
Lordship was rightly pointed out, my lords.
Petitioner number 1 could succeed.
Yes.
Segregate it. Shall I say that you will not press insofar as petitioner number 2 is concerned? At least we can examine that.
Yes. In that case, I have liberty to file separate application.
At the outset, let counsel for the petitioner submit that he would not press the present petition insofar as petitioner number 2 is concerned. Hence, the same is dismissed. Hence, the present petition qua the petition number 2 is dismissed as withdrawn with the liberty to resort to the remedy available to under law. Counsel for the petitioner to file amended memo of parties, issue notice. In the meantime, leave is granted to the petitioner to place on record the initial statement recorded in the petition.
My lords.
File the amended memo of parties. You file insofar as petition number 2 is concerned, you file something else. It's a better idea.
Liberty may be granted to. Liberty may be
Liberty I have granted.
In respect of petitioner 2.
Petitioner file amended memo of parties.
My lords.
Amended memo of parties.
Amended memo of parties.
40.
May it please, your lords. My lord, here I am challenging the order framing charge against this petitioner. Though, my lord, on materials that have been gathered in the course of investigation, if it's taken into consideration as a whole also, then no prima facie case under that offences are made out against these petitioners.
Yeah.
And this being a matter of the civil nature, then the land magistrate should have considered before framing of the charge against this petitioner, my lord.
What are the allegations?
My lord, allegation is that, my lord, that this petitioner wanted to sold his land to the complainant, that is, my lord, opposite party number 2. And that is also in a verbal oral agreement, and that too for an amount of 35 lakhs. Then the complainant handed over 3 checks, and out of those 3 checks, 2 checks that was encashed, and 1 check was bounced.
2 checks amounting to?
10 lakhs.
20 lakhs encased? And the
remaining 10 lakhs.
5 lakhs. Each check, 10 lakh, 5 lakh. Thereafter, another post-dated check, 10 lakh.
Okay.
And that 10 lakh was bounced. Then this petitioner filed a 138 NI Act case against that complainant. In that case, the complainant was convicted. The matter was come to an appeal. Here that was compromised, and he paid the twice of that amount, and that was Millard. Thereafter, he filed a suit for specific performance of the contract, Millard. And that is also pending, Millard, before the Law and Civil Justice Senior Division, Bhubaneswar. And while that is pending, he has filed that, Millard, this case only to, Millard, that to see that this person should be forced to, Millard, to execute that sale deed.
You tell me one thing.
Millard.
You have taken the money for sale consideration.
No, not at all.
Then?
There was no such transaction for that, for sale of that land. This person, Millard, the case is this, Millard. This person, along with the complainant, were, Millard, they were real estate developers. Then they engaged in business of that developing. In course of that transactions, there is some money due against that complainant.
You proved to be smarter than him.
Millard. And when that person did not pay that, then this person put that you pay me amount of those amount, that balance amount, or I will secretly pay. Accordingly, he given to check. That 2 check was encashed. And when the balance amount was there and this person demanded, that was bounced, and
But
that
they just see the plight of the opposite party. He has paid 20 lakhs to you, 2 checks in case.
Millard.
Okay. And in the compromise, he has paid another 20 lakhs.
Millard.
40 lakhs he has paid.
Yes.
What are the transaction amount?
My lord, that amount, because this
What is the transaction amount? You tell me. Come to the reality.
my lord, the transaction amount is, my lord, more than 2 crores. Because that amount, those 2 persons, my lord, found a real estate business. This person is one of the partners.
I'll
And
issue
another
notice, I'll issue notice, settle the dispute.
Millard,
Yes, you have taken enough from him, settle the dispute.
no, Millard, he has also Millard filed, and that is Millard, another I have given that CRLMC 1694 of that.
Issue notice to opposite party. Tag this matter along with CRLMC
1694 of 24. I have also mentioned Millard that in my
24. Huh? Lease it after 2 weeks. Yes.
And you also similar order that has been passed in that case.
Whose petition is
That person is Millard. That complainant is there, the accused, and I have on the basis of my complaint, he was accused and he has filed for passing of the same. The same 420 and system.
Application before time to file, please.
All right.
41.
Yes.
41 minutes. Because these arise out of 2 cross affairs, Millard. On the previous date in the corresponding matter, Millards were pleased to send it for mediation, both the matters. Inadvertently, it has been listed today before this. The connected matter is before the mediation. It is fixed to 27th of March.
Connected matter, namely CRLMC 4595 of 2024. This court, by order dated 11/2/2024, has referred the matter to High Court Mediation Center. The mediation process is going on. The matter, along with the mediation is going on, na?
Yes.
Release the matter along with CRLMC 4595 of 2024.
This has not been sent for mediation, Millards.
And this matter being a connected matter, the same may also be referred to, should also be referred to the High Court Mediation Center. Place this matter before the Coordinator Mediation Center.
On 27th March.
27th. Yes.
42.
Item 42 has been amicably settled. The informant counsel is also.
I'm appearing for the informant, my lord.
Will file in a joint application. The charge sheet has already been filed.
Charge sheet has been.
What are the allegations?
Lord, during the Ganesh immersion ceremony, the dispute arose between the parties. Only
Somewhere.
506 only allegation, my lord.
All are compoundable offenses,
Yes,
except 506.
yes.
All are compoundable. Have you checked it up?
427 is my MSG.
How many accused are there?
2 years.
Two. No, in charge sheet also 2.
Yes.
Charge sheet file against how many accused?
2%.
Check it up.
2.
Against
Two only?
the same petitioners.
Okay, issue notice. Notice has been issued, huh?
Notice has
No,
not been.
it's not been issued.
Where are they?
I'm appearing for the informant.
Where are they? They have to come.
No, they have not.
Saturday, 5th. 5th, huh? Bring them.
April.
5th of April.
May I please balance?
Yes.
Challenging the order of a discharge, Millard, that is annexure 5, order dated 6/4/2024, Millard.
6/4. Yes.
That is page 45, Millard. Order dated 6/4/24. Petitioner is a lady, Sarpanch, ex-Sarpanch, Millard. Vigilance is the opposite party, my senior is there, Millard.
Yes.
that fact matter remains in that the petitioner while discharging as sarpanch, 46 half rooms were constructed in the compound of Biju Patnai Market Complex at Paradip.
Yes.
Whereby 76 applicants are apply for the
Allotment.
allotment. It was opened and open tender was granted and open lottery system was done, my lord. Headed by the BDO. The BDO, she was the chairperson of the committee. Petitioner 7 members were there. Petitioner one of the member of the committee, my lord. That is the thereafter, my lord, I draw your lordship.
Out of 7 shop, how many of your relative got?
One, my lord. Thereby, lordship draw, my lord. Attend annexure 3 lordships. 3 annexure, my lord. Government already exonerated the petitioner from the allegations, my lord. That is 2016, my lord. Now, my lord, 2020, thereafter FIR lodged, my lord. After exoneration, my lord.
Your AP report?
No. Associate. And therefore, I draw lordship annexure 3 for grant.
3, yeah?
Yes. Annexure 3, page 37. That is order dated 4/1/16. Lordships got it, lords.
Yes.
This is, my lord, the government order where, my lord, government exonerated the petitioner from all charges. Lords, we kindly have a glass. The next page, that is 38. Paragraph like taking and last paragraph reading, my lord. Taking into consideration the order of the Hon'Ble High Court, the explanation submitted by the Sarpanch and the fact and circumstances of the case, the government is in exercise of the power conferred under section 115(3) of Odisha Grama Panchayat Act have been pleased to exonerate Srimati Sasmita Behera, Sarpanch of the GP under Ujanga Block.
Yes.
Thereafter, my lord, one my lord,
yes,
who was this person, my lord, who was appeared before lordship, my lord, your lordship exonerated, my lord, who was this person? This is the order, my lord.
Yes.
No. How can a person apply your lordship say that is order dated 3/1/25.
Who accused, huh?
Again.
One.
Who was the committee member? Your lordship classed. My senior was also appearing in that case.
No. Tapos Kumar Sadagi.
Again, one of the committee member was accused of facing the.
One of the committee members.
Again.
Yes. What is the how will you go take into consideration the
I got
annexure
it,
3?
that he relies basically his submission raised on that annexure.
Three.
That is the.
You are let off by the governments.
Again.
But before I answer this one more, let me place another point more. In fact, there is a scheme known as Urban Amenities in Rural Area Scheme in 2006 and 7.
Yes.
46 shop rooms were allotted, so it decided that it will be they will resort to lottery system, and government order was issued on 26 November 2012. If lordship permits, my lord, this same instruction, take case about that. The same instruction which that he was a OS officer, my lord. In that case, your lordship allowed that case, my lord. OS officer, he was dragged by the ADM only, they put in that committee, my lord.
Para 10 of my judgment.
Yes.
Read it.
OS officer would be.
Para 10.
My lord.
Read it, para 10.
My lord.
The result of the chart sheet reveals that it is the kith and kin of the ex-Sarpanch committee members having allotted.
That's the reason I asked.
My lord. Video
whatever, that is the reason I asked.
Your lordship, my lord,
how many of your relative got? I have quashed because he was an officer. He had nothing to do with that.
That was the first question lordship put.
I understood this.
Then more role open tender, open lottery.
I'll simply issue notice, I'll examine it, but you don't have it.
My lord, I would have got a Jodi similar, my lord, Amar Hegala, open lottery.
You are the kingpin.
No, my lord. Government exoneration got the
exoneration government. You are the kingpin.
Lordship kindly peruse that instruction. That particular instruction I placed your lordship at the time of disposal of the early case, my lord. That you also can 2-3 paragraphs, my lord.
Open lottery.
I agree with my lord frame with regard to my lord. There is no fiscal
loss.
Only my lord favoritism.
Favoritism. And favoritism is also a type of corruption.
Distinguished fact involved in this case is, my lord, this gentleman was dragged practically by the BDO, who was not to be there. The ADM should be the
I'll issue notice, let us see. Let us
ଆଉ ଗୋଟେ ଓପନ ଟେଣ୍ଡର ଓପନ ଲଟେରୀ ହେଇଛି କାରଣ ଯିଏ ଯାହା ପାଇଲା ମିଲଟ ଆଉ ତାପରେ କହୁଛନ୍ତି ବ୍ଲେମ ହେଲା ମୋର ଜଣେ ଇଲେକ୍ସନ ପାଇଗଲା ମତେ ବ୍ଲେମ ଓପନ ଟେଣ୍ଡର ହେଇଥାନ୍ତା ଓପନ ଲଟେରୀଟା
The petitioner is agreed by the order dated 6/4/2024 passed by a special judge Business Cuttack in TR case number 30 of 2017, whereby the application for discharge has been rejected. He has the petitioner is relying upon the judgment of this court dated 29/1/2025, passed in criminal division number 257 of 2022. Tapas Kumar Sadangi versus State of Orissa. He submits that in case of the co-accused, this court has given indulgence and quashed the entire criminal prosecution. He has also relied upon
Annexure 3, that is
relied upon the office order dated 4/1/2016, passed by the director Panchayat Raj, whereby the petitioner has been exonerated from all the charges. Issue notice to opposite party, Mr. Sangram Das, President Council for Vigilance, accept notice. This is the matter for final dispute.
Malot miscase ଟା ରଖନ୍ତୁ step further ନହେଲେ trial case ମିଳିବ
Wait.
trial ଚାଲିଛି ମିଲଟ ସେଥିରେ ମଧ୍ୟ trial
You move an application. Because there are many other accused persons. Once I say you come in installment, I know. ଜଣଙ୍କର ହେଇଛି and I have distinguished that from the others.
ଆଚ୍ଛା trial ଆପଣ ତ satisfied
And there are how many accused persons are there? The entire thing will be solved.
ভিডিও যে মেন লোক চেয়ার করছে মরি চালিনি
কে বলানি
ভিডিও মরি যে মেন লোক চেয়ার করছে তো কমিটি হ্যাজ এক্সপায়ার্ড মিলন তেনু মেন গলাড়ি তো ট্রায়াল টা মিনিমাম স্টেট
राज किशोर पंडा सस्मिता लक्ष्मीप्रिया स्वाई
In total 5.
सरोजिनी महांती शिवचरण नायक everybody is facing trial.
না কে আছে না ট্রেই ସେମାନେ বেটার কই পারবে
Out of 6 persons, one died.
Short date would be the
short date till then matter short
no I stay. I know I have the experience of 2000 in the 90s the stay orders are passed, it's pending.
No, I would be lots of permission.
In 138 matters, stay is operating for about 20 years. Therefore, see, it is better that I should dispose it up early. If I give a stay, then it will go down.
Permission time petition
Adjournment for application for the petitioner on the next date of hearing only. You argue the matter, I will dispose it up. You have a case, then I will quash it. If you don't have a case, don't have a case.
Government exoneration କରିସାରିଲା ପରେ ଫେସ୍ କରୁଛି ମାଇଲଟ ଏଫଆଇଆର ଦିଆକି ଚାର୍ଜ କରିବି ଭିଡିଓ ମେଲ ଲୋକ ମରିଗଲାଣି ସବୁ ଜିନିଷ ସେମାନଙ୍କ ନାଁରେ ଗଲାଣି
Okay, will you consider that as a departmental proceeding? Obviously, it is a departmental proceeding. Exoneration is neither here nor there. It is a departmental proceeding.
ତାଙ୍କରି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ମତେ ରିଜେକ୍ସନ କଲା ଏକ୍ସୋନେରେସନ
That's right, but it is a you have to keep it.
ଗଭର୍ଣ୍ଣମେଣ୍ଟର କିଛି ଲସ୍ ହେଇ ନାହିଁ ମିଲଟ କାରଣ
that's the only point. That's what also he says. There is no physical loss. That we'll see.
ଆପଣ satisfied ବର୍ଷ ହେଲାଣି ଖାଲି ଏଟା ମୁଁ ଦେବି
Next.
ମୁଁ ଟାଇମ ପିଟିସନ ଦେବି ଲଟ୍
44.
Rejection of discharge.
Sorry?
Against the rejection of the discharge in this application.
Yes.
Here, case of conspiracy and all the co-conspirators have already been released, which your lordship has taken out of in the first order. I have also annexed those orders, my lord. For criminal proceeding against them have already been quashed. It's a case, my lord. The present petitioner is the industrial promotion officer in the district industry center, my lord, Cuttack.
Where is my order?
First order, my lord, order number 1, 26/9/2024.
26/9/2024. Yes.
The allegation is that, my lord, the petitioner, who is the industrial promotion officer, along with other officials of the DIC and the nodal agency, that is OCCF, and the private transporter, my lord, have
you seen it?
Just I want to know about how you are not. What about the fact of
Where are those orders?
I have annexed 4 series, 5 series. I have annexed all those orders.
Just check it out. He says that out of 7 accused persons, 5 has been discharged. So parity, he is seeking parity with that. If
If your
it's
lordship
correct,
would
then would
see
see
the
The factum of similarity, I would suggest.
whether similarity is there or not.
That's
Huh?
the-
Just check it up. Let him check it up. Huh? Yes.
But my lord, I pray short date, my lord, Lonnie Senior is already on
Yes,
that.
let him read it. Let him
For that instruction already I been urgent for multiple
just
times.
see 26/9/2024 order. So show it to sir.
Get the page, sir. Get the page.
First order.
What's the page?
26. No, it is
Okay.
order pass in this proceeding. Just Jyoti, just show it to you. Just show it to you. 26/9/2024. Twenty-two.
23.
23. Oh, 500.
46.
Look, here, NBW A has been issued, my lords. The allegation against the petitioner is that, my lords,
Yes, tell me.
Never on bail.
never on bail, my lords. This is a case.
Absconding. Absconder. Its charge sheet has been filed. Petitioner is an accused in FIR number so and so. So, charge sheet in this case has been filed on 5/9/2023, showing the petitioner is an absconder. Yes. 1,000. Yes.
47.
May I please, your lordship? In this case, the present accused person challenged the order dated
29/11/21 BW 20 bail.
bail order 1/9/2020.
1920 bail 29/11/2021 NBW.
NBW, okay. 1,000. Yes.
48.
14 lordship. Date of NBW is 11/2/2025 lordship.
Yes.
And on Faraday who was on bail before the court bill lordship.
Huh?
Yes. Faraday is the court bail lordship.
Give the date.
So 6/2024 bail ଯାଇଛି.
16/2024, 26/2/2025. 500.
14/6/2024 lordship bail ଯାଇଛି.
Yes.
49.
Remember the decision, my lord. 25/4/2024 is the previous bail, my lord. NBW dated 5/2/2025.
500. Yes.
50.
Note. What happened? Reconstruction?
Reconstruction. Reconstruction of
Yes, it is reconstructed. Who is appearing for the petitioner?
Robinaran Behera.
Huh?
Robinaran Behera.
Password karo.
51.
To just review matter, Lordship. We have not been given opportunity of hearing. On 12th March, this case has been taken. We obtained instruction to take liberty to file a writ appeal before the.
Liberty. Yes. To LPA.
Yes.
Mr. Vishwal and counsel for
This is the lawsuit order also.
submits that
Lawsuit order is not maintainable review.
submits that he would not press this review petition, rather reserve the right to file letter patent appeal before the division bench of this court, and the present review petition is disposed of with liberty as well. Liberty.
The delay, the 160 days delay.
Delay of 160 days in filing the review petition is condoned.
Yeah, I also filed.
The reasons stated in the application, the delay is condoned. Insofar as the review is concerned, he is withdrawn.
Well, I filed the objection to the limitation petition.
Okay, let him file it.
You also can visualize, my lord. They have filed the review petition in the year 2015. Till today, they have not initiated the proceeding to the court, my lord. First. Second, they have not filed also certified copy.
See, they have to move application there, then you raise all these points.
Then your lordship also passed this order. Kindly see this order.
I know that. But
order.
That is the reason. See, principle of natural justice.
That is your lordship.
In that case, his petition you want to withdraw, how can I stop? His petition you want to withdraw with liberty, let him.
In that case, there is not principle of natural justice. That
delay ground.
Delay ground, only delay.
The petitioner itself, my lord, defective, my lord. So I recorded my submission also. The petition is my lord, defective one, my lord. Certified copy they filed the challenge, but that not filed till the certified copy. The order challenge, my lord.
Vehemently oppose the prayer made by the petitioner on the ground that the petition itself is not, the review petition itself is not maintaining. Regarding head to the submission, regarding head to the petition and the grounds taken in the application, the same is allowed. Insofar as review petition is concerned, it is the order of dismiss and withdraw. Yes. Next.
52.
On behalf of the CORAM, please provide 7 days, 7 working days.
Delay?
7 working days opposite to.
Sorry? You have not taken the steps. Are you sure that you want to do it? 2015 matter, notice was issued, you don't do anything.
7 working days.
Sorry?
7 working days.
Why should I give you date like this? It is dismissed in default. This court give you indulgence for restoration. You don't file requisitions. No steps has been taken by the petitioner for serving opposite party number 2 to 6, despite several opportunities. The letter counsel for the petitioner seeks one more opportunity to take steps. This matter is pending since 2015 regarding it to the above. cost of 1,000 rupees is imposed on the petitioner to be determined with the High Court Bar Association. Necessary steps are to be taken by the petitioner within 2 days for serving opposite party number 2 to 6. Failing which the CMP will be dismissed without reference to the court. Within 2 days, if you don't take step, it will automatically dismiss.
53.
53, this is just like 51.
2004, see, 2000, do you have anything on the writ petition? Still survives.
I do not know, yeah, on behalf of Deepak Malhotra.
2014 writ petition dismissed in default. You filed 2015 the restoration. Notice was issued in 2016. Till today, you have not taken step. Why are you burdening the court like this? Within 2 days, huh? Without reference to the court, it will be dismissed. Yeah.
53.
53 is just like 51.
Even more than 6 months.
No opportunity was given at the time of fresh admission. It was disposed of.
They were heard.
Yes.
They were heard. My lord, your lordship kindly see the order.
I know the number. I've seen it, but he wants to withdraw it.
And that apartment, yes,
Withdraw
lord,
it. Withdraw it. Yes. There is delay.
Delay 189 days.
more than 6 months.
Same
delay,
for
lord.
189 delay. Objection.
Yes, ma'am. My objection may be noted. My lordship, no liberty should be granted for it. Because that will be, they will take a right for their right.
Even if I don't give liberty, the
They have the
right is always there.
Yes, that is there.
Whether I give or don't give, how does it make difference?
For that reason, there should not be any liberty. They have the right.
They have right.
Liberty.
Liberty. Yes.
Bro, that will be handled for them. For limitation regarding the.
Yes.
54.
May I please, Your Lordship? Your Lordship, I am for the petition, my lords. My lords, I pray for 2 weeks, my lord.
Sorry?
I pray for 2 weeks, my lords.
Why?
My lords,
Interim order is there.
interim order is there, my lords, but the
2021, you have
My
taken
lords.
interim order.
my lords, my another of the conducting
There is
council
no
is bad.
opposition. Yes, madam.
Your lordship may have a glance there on the small prayer, my lord, and they are taking always time.
You can't take stay
Yes,
like
sir.
and keep on asking for adjournment.
My lords, 1 week, my lords.
Why 1 week?
A dilapidated condition.
What do you want to show?
My prayer was to repair the thatching house.
My lords,
And
there,
No, what is this matter?
commissioner.
my lords,
by the-
annexure 1 is under challenge.
One
Some-
minute.
something which is not paid for that has been ordered by the court below, my lords.
What is this matter is about? Let us understand first.
Dispose of the case, my lord. Annual thatching could not be done, my lord. Now the house is a dilapidated condition. So your lordship may dispose of, your lordship may.
See,
pass
you
any
got
order.
this, got the interim order on 23/8/2021.
My lords,
And yeah, thereafter you are seeking adjournment.
my lords. My lords, 1 week, my lords.
Cost, you pay cost. Otherwise, I'll vacate this thing.
My lords,
You can't do
pray
like
for-
this.
My lords, I
No,
just
you
pray for
ask
1
to
week.
take a stay and thereafter keep on asking adjournment, one pretext or the other. You can't do that.
My lords, I just pray for 1
You
week.
can't
my
do
lords.
that. There is opposition. There is opposition. Right up. Learned counsel for the petitioner seeks an adjournment on the personal ground.
My lords, by tomorrow, my lords.
No, I can't adjust my board according to your choice. There is a stiff opposition by the counsel for the opposite party on the ground that the interim order was obtained by the petitioner on 23/8/2021, and since then
Pardon, my lords.
the petitioner has been seeking adjournment. Regarding head to the aforementioned, although the matter is adjourned to after 2 weeks, 3 weeks together.
Pardon, my lords.
However, it is subject to payment of cost of 1,000 to the.
My lords, I just pray, may I pray for Passover, my lords? May I pray for Passover, my lords?
You pay 1,000.
My lords,
If he comes, then he will.
my lords, we are almost ready, my lords, with the matter. My lords, just needed some, the conducting council is bad.
What was your instruction? Seek adjournment.
My lords,
Your
adjournment.
senior will come and repeat the same thing.
My lords,
I will increase the cost if your senior
I'm asking
comes.
for adjournment because one.
Pay 1,000, enjoy the cost.
No, my
Enjoy
lords.
the interim order.
My lords,
For another.
I am paying for adjournment because one.
See, there is opposition, sir.
My lords, there is opposition. I am not arguing that. My lords, the thing is,
The
the
opposition
community
is-
council badly placed now. That's why I am praying for adjournment, my lords. I just pray for
Pass it
personal.
over,
My lords, my
Pass
lords,
it over.
my lords.
The order रखी था? Yes. नहीं opposition. It's opposition. Yeah.
If I made a review application, but I have not got with that review petition, I have not got it from the notice. Only the IA has been issued and the.
On the question of delay, notice was issued.
So how could I, the objection I could not find?
Are you opposing the delay?
Yes, my.
Have you filed opposition?
No, my, I have not got the.
Learner counsel for the opposite party submits that he has not received the copy of the review petition as yet.
By tomorrow, I'll sir.
Petitioner undertakes to supply the copy, release the matter after 3 weeks. Yes. File the response.
56.
Please, your lordship. Here, on the last occasion, your lordship directed to serve the notice to the report is there of the learned SDJ, my lord.
I am appearing for the, I have instruction to appear, but till date I have not filed Baklatnama. But here what happened, the CRLM was filed for restoration of CRLMC number 4110 of 2021, which were dismissed for default since May 2021. And in the meantime, I was appearing for the opposite party there, my lord. In the meantime, they have, in that case, they have filed CRLMC for quashing of cognizance. And by now, the evidence has been closed and the case is posted for accused statement.
No.
I can't entertain this.
My lord.
I can't entertain this.
My lord, your lordship, let it be restored. Tomorrow, let it be.
I will restore and dismiss.
My lord, thereafter, after hearing if your lordship feels that
see,
it is a fit case.
You came against the cognizance order.
My lord.
Dismiss in default.
Check bounce case.
Dismiss in default. Okay? Dismiss in default. By now, the evidence is over and everything.
My lord, there is a recall application for recalling the PW1. My complainant was examined.
You have to move there.
Well, I have moved, but I have challenged the cognizance order. Your lordship may restore it, put it to tomorrow, my lord. Let it
complete.
My lord, when the cognizance order is challenged on the basis of that the check is given for some other purpose.
But if you are so sure about it, why have you not prosecuted?
My lord,
quite and allow the track to go.
My lord, it was stayed. It was stayed till.
I know it was stayed. Therefore, you are insisting. I know that if there would not have been stay, you would not have asked for it.
No,
I'll restore it without stay.
No.
I'll restore it without stay.
No, my lord, what has happened? My lord, earlier another council was conducting this case. My lord, stay was there. When
you file, tell all these things in file.
Objection move
appearance for opposite party and seek an adjournment to file objection. And Vokalatama, let him do so within a week. Release the matter after 3 weeks. Let him file. We'll see.
I will file Baklatnama
and objection also.
Objection they may serve a copy of limitation petition
for the petitioner undertake to serve the copy of the petition.
Limitation petition also.
Yes.
I will file
my lord, a date may be
fixed. Date will be fixed after 3 weeks. Yes.
Obligement.
57.
By that time, he should be convicted.
No, my lord.
By the time he should be convicted.
My lord, because he could not know that stay is my lord, dismissed for default, they proceeded with the matter for examination evidence, then he came to know that.
Then how diligent you are, just see. Matter is proceeding there. You had a stay, you don't want to restore it.
After coming to know that this case has been dismissed for default or non-appearance of my advocate, then
diligence is writ large.
My lord. Again rejection of application under section 457 CRPC, my lord. The petitioner along with two others.
Yes.
They are involved in a case under section 420, 406, 201 and 120B IPC. And while in course of investigation, a sum of rupees 7 lakhs some odd was seized from the co-accused, namely one Ishwar Meher. And he stated
in the
that
house of Ishwar Meher. In the house, because
in the house of the Ishwar Meher, in course of investigation, he filed an affidavit before the court in session about the matter.
Who are
saying that
you are,
I'm one of the accused Manas Rana.
so how the,
I
why-
filed an application under section 457 CRPC.
I understand it, why the money should go to you?
Yes.
No, pending 2020 matter.
Maybe, but are you the owner?
In the event of, Your Lordship, see the affidavit shown in by the other accused from whom the money in question was recovered. He has paid a sum of rupees 50 lakhs. I have taken money that is on account. Everything was in record, madam.
Let us see the order.
Yes, madam.
Let us see the order.
Page number 17, my lordship.
Here the
What are the reasoning?
May I please the paragraph of the
Read
page number 17, my lordship. The present petitioner against whom there is an allegation of cheating, misappropriation, embezzlement, swindle, etc., is not entitled to get the money without due disposal of the original case. That apart the seized case may be required by the court during the trial. Thus, I am of the view that the impugned order dated 28/3/20.
What is the stage of the trial now?
My lordship, that I have not taken. It is
What is the stage? Except impugned order, you have not filed a single
lordship-
document.
My lordship,
That's the whole difficulty you people talk.
initially it was the case of 394. Then it comes after investigation, it comes to know that it is the case of 420, 406, 201, 120 BIPC. Because
The
they
court says that unless the case is disposed of, I
Yes.
can't do it.
Yes.
Let us know what is the stage of the
that
case.
file is
If it is a fake end, then why should I enter?
May I please keep in Friday? I will.
Not Friday, you tell me. I will do. Will you give bank guarantee?
Bank is property security.
No, bank guarantee if you can give.
this money is not belongs to the petitioner, neither his friend, nothing, my lordship. It is of the there is a form of a cotton farm, my lordship. Poor farmer is working, and that money belongs to them only. And they have misappropriated this money, my lordship, by giving a false false information to the police that the money has been docketed by them.
You are not entitled.
No, my
Your Lordship, see, at the instance of the petitioner, affair was lost.
Where will I see?
My Lord,
Where will I see?
Your Lordship, see, the other.
Where will I see?
Your
You
Lordship,
filed only impugned order. Where is the FIR? Not a single document.
may.
Where will I see? I see
Your Lordship, keep it
there.
next to any day. I'll. Your Lordship, keep it next to any day. I'll file the entire.
Petition you are people.
No,
are filing, I don't
I'm aware of
understand.
this. I'm aware of this. Your Lordship, keep it next to any day. I'll file it. FIR charted everything on record, my Lord.
Nothing is
And
placed
I will
on record.
prepare it. I'll submit it same before Lordships.
And in the petition also you have not said what is the stage of the trial.
2020.
Not anywhere single.
Your Lordship, keep it next to any day.
I'm struggling to get what is the FIR number, what are the offenses.
Yes.
Nothing is there.
Your Lordship, keep it next to any day.
Not next week. I can't adjust my board according to your choice. It will go to July. Put it in July.
Before vacation,
No.
I'll file my Lord.
July. If this kind of petitions are being
I'm
filed
sorry,
here,
madam.
you are wasting court's time. How these
No,
petitions
last
are
time,
being
Your Lordship, directly
entertained
take
at-
instruction from whom the money in question was seized, let him file an affidavit. Along with the document, I filed
Why
the affidavit.
you file a slip, 1 page slip, and for you annexure will be
No,
collected by
along with the
the
affidavit. Or if CD has come, that is what I did. Let's keep it next week, a week after, my Lord.
after 4 weeks. No casual petition.
No, I'm sorry, my Lord.
Stage of trial.
In fact, I'll brought the entire affair,
Yes,
charted
next-
everything
next-
on record, my Lord.
58. And defect is also not cured by you.
But,
Defect pointed out into this is to 2022
Yes, sir.
file.
that formal defeat.
When have you filed the petition?
My Lord. It was filed on 11/10/2022.
2022.
Yes.
And defect is pointed out. Defect is not cured. No document is filed and is pending since 12. I will allow you to file a fresh petition, withdraw it. Let
No, Your Lordship.
petitioner seeks to withdraw.
Again, I have to move before the trial to
Yes.
the phrase.
Yes, because the trial might have been proceeded long.
You Lordship, keep it filed, my Lord. I will.
Withdraw the petition with the liberty to file the fresh application before the trial court under section 457 CRPC in the changing circumstances. Since the present matter was filed, since the present matter is pending since 11/10/2022, challenging the order of the trial court dated 21/5/2022, whereby his application under section
By the revisional court, that is by the revisional court.
rejected. And rejected on the ground that till the disposal of the trial, the gas seized from the co-accused cannot be cannot be disbursed to the present petitioner. Present petition. The stage of the trial, nothing is placed on record except the impugn order in the present petition, from where it could be elucidated regarding the stage of the trial. Therefore, the petitioner, the present petition is dismissed as withdrawn, with the liberty to the petitioner to file a fresh petition before the trial court under section 450 along with the all relevant documents.
Yes.
Such application is moved, same shall be
That
later on.
you'll adjourn it to 4 weeks. You'll do that, and then
Yes,
in the event, I'll submit the.
I should have dismissed it with cost. I'm giving you relief.
In fact,
You
you'll
will
also
be happy and go.
This money itself, so in previous trial, could ever please supply since. No, I'm aware of the.
You can't.
Yes, I'm aware.
Disservice to the institution. 2022 you have filed. Defects are pointed out. You have not cured the defects. And you have not filed anything except the impugn order. Not made any averment in the petition.
No, averments are what in fact.
To what extent one can tolerate, you tell me? Yes, I have given you the, liberty. Now you file a fresh one. The court may consider it. Yes.
58. A dispute between the husband and wife which has been compromised, but the wife is not, in spite of notice, did not enter appearance. May I premier no instruction? Your lordship may dispose of no instruction whenever the liberty granting, whenever the cause of
The land counsel for the petitioner submits that Mr. Bhukta, land counsel for the petitioner submits that he has no instruction from the from his client petitioner. Hence, the matter is disposed of with liberty to the petitioner to resort to the remedy available to him under law at appropriate stage if cause of action subsequent. Okay.
60.
My lords, both parties are compromised. My lords, last occasion, both parties also present on the court, and you also see direction to follow the recent judgment. For
That yes, my lordship, I have seen that. But one thing is, my lordship, here also that same, they are in love, and the age of the victim as well as the petitioner is almost yes, 24 and 20, my lordship. So
have you read the recent judgment?
Yes, I have also.
My lords,
let him read it.
My lords, my lords,
yes, I
my
have.
lords, both are out of state. No coercive action. I am a file.
First, read the judgment. You satisfy yourself. Read
Next date, my lords.
Read the judgment. Okay. Notice was issued? No, issue notice. Huh? Issue notice.
Notice already issued, my
What is
lords.
the stage? You have not, see, notice was issued, you have not taken steps. And you need.
Given already step, and both parties are also present, my lords.
See,
And
the court is
1912,
not taken.
1912-24, my lords. And joint affidavit also filed.
Where are they? Anybody is appearing for opposite party?
No.
Steps, the report is you have not taken step.
My lords.
Right of pursuant to the order dated 21/11/2024, no steps have been taken by the petitioner to serve opposite party number 2 and 3. Land counsel for the petitioner seeks one more opportunity to serve 2 and 3. Lease the matter. Yes.
My lords, no coercive action. I file IA.
Why are you insisting me to dismiss your petition? First of all, you have not taken steps. Now you are asking for adjournment. Yes.
61.
61? Withdraw.
May I permit to do withdraw, my lord?
Yes.
My lord.
The notice was answered due to address is not found.
No such person.
498A, the 498A to 323 and 34.
Why you karo bhaiya?
So the notice to be.
There are 2 weeks time may be granted to
But-
collect the correct address.
You collect the land counsel for the petitioner seeks 2 weeks time to collect the furnish the fresh address of opposite party number 2. Permission is granted. The petitioner may file the fresh address of opposite party number 2. In the meantime, the IO of the case be also directed to serve notice on opposite party number 2, lease the matter after 4 years.
64.
64 extension of time for surrender. Extension of time for surrender, my lord.
Extends for the reasons stated in the application. The time granted to the petitioner to surrender before the surrender appearance before is extended up till 20th April. It is made clear that no further extension shall be granted in any ground whatsoever.
65.
65 in a Belgium case, disposal had order dated my lord 16/1/25, direction to petitioner pay 1,000 rupees to the victim my lord. Petitioner deposit about victim is not come. Therefore, date expire. Only I pay I deposited in the shape of bank draft in her name, and date may be extended. Only that.
Okay. By the order dated 16/1/2025, this court has directed the petitioner to pay cost of rupees 1,000 to the victim. However, the land counsel for the petitioner submits that the victim is not available.
No, I mean, notice I issued, but she has not notice I issued to victim through PS, but
therefore the cost could not be paid. Accordingly, he seeks direction from this court to deposit the cost in the name of victim by bank draft. Let him do so within a period of 2 weeks. For the 2 weeks, the time for surrendering from the court below is extended up to 25th of
deposited in the trial court.
67.
Your Lordship, requesting me pass over after lunch.
67, I'm for the opposite party number 2, Your Lordship. I have received wakalat number. I'm for the opposite party number 2, Your Lordship. I have received wakalat number. Copy may kindly be supplied, Your Lordship.
Okay. And so pursuant to the order dated 3/3/2025, so entered appearance for opposite party number 2 and files the wakalat number. He submits that the copy of the petition has not been supplied to him. Land counsel for the petitioner undertakes to supply the copy during the course of the day, leaves the matter after 2 weeks. Yes.
Obliged.
Modification of order, para 2 of the order, instead of special judge vigilance Sambalpur to special judge Sambalpur.
Para 2 of which order?
Order dated
68,
12/3/2025. Para 2 of the order.
12/3.
12/3/2025.
Fine, 12/3. Where is that order? Do you have that order?
That's it.
Do you have that order?
Okay. Order ta pakhare nahi.
This is a fresh petition, there is no order.
Order ta file ହେଇନି. Order ta file ହେଇନି.
Huh? Where is that order? Not there.
Order ta file ହେଇନି.
Do you have that order with you?
Order, I don't have no.
You want modification of an order, you don't have the order also. Have you read that order? Have you read the order which you are seeking for modification?
No.
Then how have you moved the application without reading the order?
Only pending before the London Special Judge Sambalpur instead of London Special Judge Bargad.
In the prayer you have written Bargad, what to do? Just see in the main petition. Main petition, you have written Bargad. Let's see the main petition. Page 5. Special Judge Vigilance Bargad.
Yes, Lordship.
You have written.
Bargad is right.
Right.
Lordship.
What is written there?
Lordship, the wrongly Sambalpur.
Well, show me that order. Whether Sambalpur is written or Bargad is written? Sambalpur written.
Pending achi Bargad re. Sambalpur in the meantime transfer is. Sambalpur ru Bargad ku transfer is.
Special Judge Sambalpur. It is Sambalpur written.
Lordship.
So what do you want?
Bargad.
Okay. Sambalpur there. And Borgad we had written, you went and asked them to write Sambalpur, now you are saying.
Sambalpur PSK से Sambalpur order टा pass है जी Sambalpur किंतु pending before the now the pending case is the Bargad, that is the error.
Borgad karo, Borgad karo. Borgad. For the reason stated. Yes.
69.
Withdraw.
69. 70.
Yes. Hello, I may permit you to withdraw and liberty may be given to file better application. And further, I am praying for one thing, Your Lordship. Order may be passed for return of certificate copy. Yes.
Certificate copy return kar do.
Annexure 1.
Yes,
sir.
certificate copy. Replacing the.
Oh, please.
70.
70 minutes, so old suit minors, but any minutes that minors have directed to take, the registry to take instruction, what is the status of the suit? My instruction is that the suit is pending.
The report has come.
Report has come.
Civil suit number 162 of 1988.
162 of 80. Because it is the 80 of the suit, but on remand it is now re-adjudicated. Appeal, if the suit was disposed of, appeal preferred, then it was remanded. On remand, the suit adjudication is going. ସେତେବେଳେ ଥିଲା CMP CMP has come in year
Pending now. Have you seen the order? Have you seen the report?
No.
Have you seen the report is pending?
That is pending. But my instruction that is pending.
Yes.
Will be taken up for we can can be taken up for final hearing matters. Because I think matters one decision and one the judgment of the lower appellate court, a copy of the judgment of the lower appellate court will be required.
What is this matter? Because the interim order is operating.
Matter 12. Yes. Matter is very simple. There is a dispute concerning title and possession. It was decreed. Appeal preferred. Appellate court matters directed remanded the matter for fresh hearing.
Yes.
Including the Commission of Endowment as a party, as required under Section 69 of the Orissa Hindu Religious Fundamental Act. So that accordingly, the Commission of Endowment was pleaded because the dispute is whether it is a private duty or it is a public duty.
Whatever.
So there, Commission of Endowment didn't file any written statement, but wanted to cross-examine one of the party. There, we filed a petition. You cannot do that. One part. The second part is that
why can't the defense is struck up? Does it mean that he can't cross?
They cannot. They are not disclosing their stand. Whether it is a
private not necessary for cross-examination.
Cross-examination, they can be entitled to, but subject.
He can't lead his own evidence in the absence of pleading. But he can cross-examine your witness.
That exactly matters. Why this is required? I will bring it. Matters just the facts for the particular fact.
Yes.
The second part is very important. There we wanted to raise additional evidences for the adjudication. That was rejected on the ground that the court, the lower appellate courts categorically stated that it will be limited to cross-examination of the Commission of Endowment only. Whether it is the observation of the lower appellate court or it is open remand. That is to be taken care of. If that will be so, then because Commission has come, now we have to adduce evidences in strict terms. We have to adduce evidences in detail, whether that is a private duty or not. It requires adjudication. That is what we prayed that we may be allowed the kind of a glass to annexure 1.
What was challenged in the writ petition?
The writ petition was that order of rejection, limiting it per kind of a glass to annexure 1.
Where is that annexure 1? Yes.
Annexure 1? Then minus annexure 2.
Only he is allowed to go cross-examine.
Cross-examine. Then, my lord, Annex 2. We said that we will be allowed to adduce evidences, but page 1 2 minutes. Upon perusal of the order of the appellate court, it is observed that the parties are to produce the witness already been examined for further cross-examination by the Commission of Endowment, who have been included in the defendant 7. Here, PW1 has been produced by the plaintiff, and defendant 7 has sought for permission for the cross-examination. In view of the order of the appellate court, this court does not see any reason to refuse permission for cross-examination. In view of the above fact circumstance, the court is inclined to allow the permission of cross-examination such and such. Then, madam, the page 13, the order.
13, yes.
Last portion. Last portion, page 13, last portion.
Counter to the petitioner.
Upon perusal of the order of the London appellate, this court observed that the petitioner does not have any scope to cross-examine the plaintiff at this stage. As per the order of the appellate court, the Commission of Endowment is only entitled to cross-examine the witness already examined in this case, if he so chooses. In view of the
By the way, why can't the trial court, the suit court will decide all these things? Suit court can take a call.
Well, that exactly London lower appellate court, that copy of the judgment is not legible. That is what I am unable to produce. The London lower appellate court, while remanding, has said, keeping all the parties open, the evidence adduced can be subjected to cross-examination. Any party can adduce additional evidences also. And propriety of that evidences, the trial court can take note of. This is what they say. But they limited, no, you cannot. Only the commissioner endowment. None else. That is the contrary to the finding.
Because the trial court, the remand court has only said that you implead endowment. And insofar as the cross-examination and everything is over, they have already done. Only the newly added party will get the opportunity. That is why it is said. What is wrong in it, I don't know. 2012 it is pending.
Can visualize one thing. That is very important, pertinent purposes for adjudication is concerned. Here in this case, the remand order by the London lower appellate court is limited to the cross-examination by Commissioner Endowment only. My case is that because of the fact that
in this writ petition, what have you challenged? Let us understand. Let us.
I pray I will cross-examine the plaintiff.
Annex 2.
Annex, it is probably it is wrong. Annex 3. It will be Annex 3.
Where is that?
Annex 2. Annex continuation. Annex 2 is in continuation.
Page 13 is the order which is there. Page 13, order dated 16/4/2012.
Yes.
16/4/2012.
What your lordship is telling, that is reflected in the order. We limited to cross-examination by the endowment commission only, excluding all the evidence that has been taken.
My humble contention is that I filed a petition there. I wanted that I should cross-examine the plaintiff in view of the changed circumstances. That changed circumstances. The London court rejected on the ground that the London lower appellate.
Have you amended your plaint? Have you amended the plaint? Have you amended the plaint after remand?
No question of amending the plea. But why?
No. Have you amended the pleadings?
No.
There is no amendment of the pleadings.
Question of amending the pleading.
Then why should the evidence will take?
There the whole total probably I can trace what is the suit for. But the thing is that the suit is that forget about all the part what was there. I purchased a property from the Marfat Das of the deity. The deity, thereafter the dispute arose whether it is a property, it is a public religious endowment, or it is a deity, private deity, or it is a trust deity.
Yes.
Trust deity. Now, question is that private this suit was disposed of on the ground that it is a public deity, and that is what the appeal preferred. Plenty percent the appeal was preferred.
Yes.
Or in appeal it was remanded, but on the ground that it will be adjudicated whether it is a public deity or a private deity. Now, in view of this minor issue frame, but contingency requires, it requires further evidence. No, also it requires further cross-examination and examination. That is what I filed a petition, because I am not the plaintiff. I am the defendant. I wanted to cross-examine the plaintiff in this regard. That is what I filed a petition there. The court rejected on the ground, merely a simple thing, would have allowed this and she could have been started since long. could have allowed cross-examination. There is no bar of not cross-examining the parties because the lower appellate court have given that liberty.
Where is that?
That is not legible. That is what I pray, madam, may taken up day after tomorrow so that I could have.
What 2012 this matter is pending unnecessary.
Tomorrow, madam, that is not.
No, not today only I finish.
No, that is not.
These are the matters. Within seconds it should be over.
No,
2012 it is pending.
That is, there is nothing in it.
What is great about it? I do not know.
I'm reading it, madam.
Yes.
Therefore, the suit is remanded to court of the learned additional civil judge, Junior Division Basudepur, with the direction to issue notice to the Commissioner of Endowment Orissa in conformity with the mandatory requirement of Section 69, 1 of the Act, to hear the suit afresh.
Hard copy is
Get the
hard copy. 2012 matter.
High Court order division.
Are you conceding to him? You will cross-examine or what?
The appellate court order has not been challenged.
No, lower appellate court.
No, he says that his right flows from the remand order itself. That's what he says.
Remand order specifically quoted in the impugned order. The learned.
Where have you quoted?
Page 14 of the date petition.
14.
Page 14. Giving the reasons. Upon perusal of the order of the appellate court, it is observed that the case has been remanded with a specific direction, which reads as follows. Now, this is the direction. The witnesses already examined are directed to be produced in the court for the purpose of cross-examination by the Commissioner of Endowment. If he chooses, the evidence already adduced in this suit shall deem to be the evidence after remand subject to further cross-examination by the Commissioner of Endowment.
That is a part. That is a part.
Why have you not challenged that order?
That is
If
a
not
part.
challenged, then you are bound by that. If you have not challenged that part of the order.
That they have quoted a part, learned trial court quoted a part of that order.
Which part you are saying that you? Yes, which part? Come at 2 o'clock. I'll dispose it. 2 o'clock. Come with that. I'll dispose it up. There is nothing.
Oh, that is the point, my lord.
I am wondering why 2012 it is pending.
Exactly, my lord. That is the thing, my lord. That is another kind of. I made it.
Yes.
2 o'clock. Yes. Therefore, the suit is remanded to the court of the learned additional civil judge, Junior Division Basudepur, with a direction to issue notice to the Commissioner of Endowment of Orissa in conformity with the mandatory requirement of Section 69 of the Act, and to hear the suit afresh. Hear the suit afresh.
Vis-a-vis
After calling upon
Commissioner.
parties. After calling upon the parties to adduce further evidence. And also direct the witness already examined. And also direct the witness already examined be produced in court for the purpose of consideration by the Commissioner of Endowment if he chooses. This part of upper part of the afresh consider the
Next sentence.
The evidence already adduced. That is, there is no doubt about that. That will be there. The evidence already adduced in the suit shall be deemed to be the evidence after remand subject to further cross-examination by the Commissioner. As last part of very important, as the parties are given opportunity to adduce further evidence before the learned court below, I am not inclined to give any finding on acceptability of additional evidence.
Okay. Hard copy.
Both parties have been
I'll pass the order.
both parties have been given that right. Both part consider.
These. I'm wondering why it's pending.
Only thing is that examination cross-examination total
I understood. I'll pass the order.
It amounts to reopening the suit.
Obviously, High Court, High Court decision division bench decision of Justice P.C. Mishra, my lords, comprising Justice P.C. Mishra, so the 169 is not complied with, when Ochari Act, it will go back to the original position. Original, it will go back to the original petition, not ଏଥିରେ ସେଟା ଏତିକି limit କରିଛନ୍ତି ଯେ ଯେତିକି cross examination ଯଦି ହେଇଛି ଯଦି commissioner endowment ଚାହିଁବେ they can both parties are free to adduce evidences, then the court is free to accept these evidences.
Let the court take the call
Court
at the right stage.
Yes. ଏତିକି
Let the commissioner lead his evidence. If so required, the court will take the call. Remove application.
Parties have been given that opportunity.
We'll see. I'll see. I'll adequately pass. Yes. Yes. If you want to give anything in writing within 2 days, you give it.
I will give it within 2 days. Only କିଛି ନାହିଁ ଗୋଟେ ଜିନିଷ ହଉଛି
Within 2 days, you give it. I'll pass.
given liberty first line ରେ ଯେ ସେମାନେ they can adduce further evidences, cross examine evidence ଯାହା କରିବା କଥା କରିପାରିବେ. Endowment commission କୁ କୁହାଗଲା ଯୋଉମାନେ ଦେଇଛନ୍ତି ଯଦି ଚାହିଁବେ they can be ଦିଟା part, ଗୋଟେ part କୁ ନେଲେ ଗୋଟେ part କୁ ନେଲେନି. ଏଠି defendant କହୁଛି ମୁଁ ହଉଛି defendant ଯେ I will cross examine the plaintiff again. Because the whole total suit has been set aside, remanded, only cross examination ତାପରେ ଜିମିତି କରିବା କଥା ଯାହା ଚାଲିବା କଥା ଚାଲିବ. ସରିଥିଲେ ଚଳୁ ସରନ୍ତି. ସରିଯାଆନ୍ତି.
I'll target it out.
Yes, obviously. କାରଣ ଦି suit minus
Suit, original suit କେବଳ
88
1988.
So suit. Only point is this that yes, it is an open remand. Parties are free to adduce evidence. Evidence ଦେଇଥିଲେ ମଧ୍ୟ କିଏ ବର୍ଷ ଭିତରେ ସଚ୍ଚା.
Anyway, I'll see.
ନା.
Yes.
ଗୋଟେ part. No.
Already the evidence that has been given, so that is there, that will be there. Only
I'll see.
That evidence will be there. Any party may lead further evidence, cross examination, examination, and thereafter commissioner endowment. এবং সমস্তଙ୍କ total evidence to be appreciated by the court below, whether acceptability, it is acceptable or not.
Yes. Next slide. Yes.
71,
After lunch, you know.
71 password. Yes.
72.
Notice has been served on the OP number 2.
My lord, I am appearing for OP number 2.
Okay.
Later copy is sir. We haven't
Like to
received the
file
copy.
objection.
I will file the wakalat number today.
So enter appearance on behalf of opposite party number 2 and 6 time to file wakalatnama and objection to the petition. Let him do so within 2 weeks hence. Release the matter after 3 weeks. Interim order to continue.
73.
73 may kindly be password.
My lord, and for the opposite party, my lord directed to for the mediation. Because it is failed, man.
Mediation failed.
Then it may be hard, very.
The parties conjointly submit 73 conjointly submits that the mediation has been unsuccessful. Matter is to be heard on merit. Leave the matter after week interim order to continue. Yes.
74.
Please, my lordship. My lordship, last time the opposite party appeared and they have taken time for the conciliation or whatever mediation about that.
No, but there is no chance, sir.
No chance. Yes, madam. No chance.
I have filed quashing of the FIR, my lordship. False case they are lodging and they are in my house, my lordship.
Several cases are pending between there. Even if suit is pending, status quo order has been passed in respect of.
Status quo order has been vacated also.
Maybe, but the suit is pending regarding my friend.
That's the reason because she herself is involved.
Yes.
So therefore, that's the reason I was thinking that it should be.
But why they have executed the will? If your lordship, she kindly also she as the father of the present petitioner has made a complaint before the Human Rights Commission since how she has been harassed, and a case has been registered against since 2013 before the court below the 498 is so many offense. Lordship, kindly.
Even they were in custody, my lordship.
Yes, that is not disputed.
They were in custody.
That's the reason they don't want to settle. At your instance, they have gone.
They have taken advantage of my father, my
The
lordship.
brother and sister taken care of the father of the petitioner.
That's why they have killed my lordship.
Only property dispute you converted to all criminal matters at all. Yes, then we'll hear it. Hear it out.
Yes, regarding quashing of the affair.
Simply urgent. The counsel for the opposite party submits that there is no scope of settlement in this matter in view of the checkered history of the case. History of the case. Leaves the matter for final disposal of the case. 76.
Please keep it to Sunday.
Both the
Urgent wife.
He'll give it.
Okay. 76 kindly pass on, my lord. Both the husband and wife are on the way, my lord. They are coming from removed area.
What are the offences?
The document has already been filed, my lord. Entire order sheet showing that there is no filing of charge sheet, my lord, in the concerned court. Last occasion, lordship insist for the
Charge
order
sheet has
sheet.
not been filed.
Yes, not filed, my lord. That is on the flags.
They are married.
Yes, they are married and blessed with a child, my lord. I've also getting the
Okay.
birth
Let's see.
certificate.
So is their charge sheet is not filed, they are married, blessed with a child. Okay. Pass over.
Oblige, my lord.
Pardon your lordship. My lordship, item number 75.
Which item am I taking?
I'm appearing for the petitioner.
Oh, somebody mentioned it, got it. Yes.
Let's say after launch as.
Which one?
I'm for the opposite party.
Which one? 75.
Yes, lordship.
You mentioned in the morning.
Lordship, morning करथिले आसले देवी दत्त महापुर आसले तो.
Oh, mentioned in the morning for adjournment, I have adjourned. Yes.
Statement and clearly reflects due to the access of the present petition, the one level in that year. But is page 20.
Notice was issued.
This OP2 already entered appearance, last date this matter due to non-appearance for the OP2.
You are appearing for?
Yes, opposite partner 2, my lords.
Opposite party. Last time you didn't appear, therefore it is.
Yes,
Then
my lords.
let us see. Let the petitioner come. Pass over. Pass over. Yes. 79.
79 can look pass over, my lord.
Pass over. 80.
My lord, item 80 में kindly भी pass over, my lord. I'm on BC, my lord.
Pass over. Huh? Yeah. 81.
Yes, my lord. Affair registered under section 376D. Cognizance taken by the Lord SDM Padampur on 19/7/2024. Charge sheet has been filed, my lord. The petitioner challenged the cognizance order with a prayer for quashing the same on the ground of the informant, my lord, has already, the dispute has already been settled by the parties, and the opposite party number 2 has filed affidavit before this honorable court, my lord.
Yes.
Affidavit has already been filed, my lord.
It is 376D.
My lord.
Gang rape.
No great value. My lord, allegation only, my lord. There are two accused persons. One accused got the informant, another accused. That is the allegation. But now the informant has already been given affidavit, my lord, before this other.
The affidavit will not do.
The matter
164.
has already been settled, my lord.
Show me 164.
We tried to contact the petitioner, also communication could not be established. So kindly for taking instruction, another date may be granted.
Instruction regarding what?
Your Lordship, 143A of NI Act, that interim compensation.
I'll send it to mediation, 10% you pay.
Directed to put it 10%, then matter will be referred to the.
That's what I'm saying.
Yes.
So we
I'll reduce it to 10%, I'm sending to mediation.
Yes, Your Lordship.
Petition is agreed by the order dated 9/1/2023, passed by Lieutenant SCJM Chedrapura in 1CC case number 43 of 2019, whereby the application of the opposite party under section 143 capital A of NI Act has been allowed, and the petitioner has been directed to pay interim compensation up to 20% of the.
For taking instruction, another date may be granted.
Instruction regarding what?
Your Lordship, 143A of NI Act, that interim compensation.
I'll send it to mediation, 10% you pay.
Directed to.
Query from the court.
Put it 10%, then matter will be referred to the.
That's what I'm saying.
Yes.
So we
I'll reduce it to 10%, I'm sending to mediation.
Yes, Your Lordship.
Petition is agreed by the order dated 9/1/2023, passed by which mediation center? In High Court, case number 43, High Court 2019, whereby the application of the opposite party under section 143 and then in the meantime, petitioner has been allowed, and the petitioner has been directed 10% of interim compensation of 20% of the.
For taking instruction, another date may be granted.
Instruction regarding what?
Your Lordship, 143A of NI Act, that interim compensation. The petitioner may be allowed to pay the interim compensation in the court. So may be allowed to deposit the amount in the court.
That's what I'm saying. Before mediate. Before mediate.
I'll
reduce it to 10%, I'm sending to mediation.
Yes, Your Lordship.
Petition is agreed by the order dated
Published.
9/1/2023.
Item 10, may I praise your lordship on behalf of Mr. P.R. Singh, my lord. My lord, the petitioner as well as the opposite parties are absent today for the compromise, my lord. Lordship may keep this matter after 2 weeks.
Sorry?
My lord, the petitioner as well as the opposite party is absent today for the compromise, my lord. My lord, may keep this matter after 2 weeks.
Taking instruction, another date may be granted.
Instruction regarding what?
Your Lordship, 143A of
Please,
NI
lordship,
Act.
my lordship, with the limited time, we want to expedite
The
the
petitioner may
trial.
be allowed to pay the interim compensation in the court. So may be allowed to deposit the amount in the court.
That's what I'm saying. Before mediate. Before mediate. I'll reduce it to 10%, I'm sending to mediation.
Yes, Your Lordship.
No, when the charge was
Published.
9/7. What is the stage? You have not said anything.
Item 10, may I
What is
praise
the
your lordship
what is
on
the
behalf of Mr. P.R. Singh, my lord. My lord, the petitioner as well as the
Whether
opposite
charge has
parties
been
are
framed?
absent today for the compromise, my lord. Lordship may keep this matter
You
after
have to
2
tell
weeks.
what is the stage.
My lord, the petitioner
Not
as
a
well as the
routine order.
opposite party is absent today for
Tell
the
me.
compromise, my lord. My lord, may keep this matter after 2
Passing
weeks.
no course order.
Taking instruction.
You're an accused. Instruction regarding what?
Your Lordship, 143A of
Please,
NI
lordship,
Act.
my lordship, with the limited time, we want to expedite
The
the
petitioner may
trial.
be allowed to pay the interim compensation in the court. So may be allowed to deposit the amount in the court.
That's what I'm saying. Before mediate. Before mediate. I'll reduce it to 10%, I'm sending. Pending before which court? Pending before charging station.
Published.
9/7. What is the stage? You have not said anything.
Item 10, may I
What is
praise
the
your lordship on
stage?
behalf of Mr. P.R. Singh, my lord. My lord, the petitioner as well as the
Whether
opposite
charge has
parties
been framed?
are absent today for the compromise, my lord. Lordship may keep this matter
You
after
have to
2
tell
weeks.
what is the stage.
My lord, the petitioner
Not
as
a
well as the
routine order.
opposite party is absent today for
Tell
the
me.
compromise,
And
my
after
lord.
investigation, charge sheet
My
has
lord, may
been
keep this
filed.
matter after 2
Passing
weeks.
no course order. 7.
Taking instruction.
You're an accused. Instruction regarding what?
Please, lordship, my lordship, with the limited time, we want to expedite
The
the
petitioner
trial.
may be allowed to pay the interim compensation in the court. So may be allowed to deposit the amount in the court.
Nothing is coming before we get reduce it to 10%. Pending before which court? Pending before what is the stage? You have not said anything.
Item 10, Mayor
What is the
raising
stage?
lordship on behalf of Mr. P.R. Singh, my lord. My lord, the petitioner as well as the opposite parties are absent today for the compromise, my lord. Lordship may keep this matter
You
after
have to
2
tell
weeks.
what is the stage.
My lord, the petitioner
Not
as
a
well as the
routine order.
opposite party is absent today for the compromise, my lord. My lord, may keep this matter after 2 weeks.
An accused. Regarding what?
May I please, your lordship?
My lordship,
My lord,
today we want to,
here in this case, the informant of the case is died in the meantime, and the parents are awaiting for the outcome of the case. This is a case under section 498A and 4 DPR 307. In this case, charge sheet submitted, cognizance was taken, but the trial is till now not a single witnesses has been examined. Nothing was only expedited trial. Died.
Lordship may keep this matter
What
after 2
is
weeks.
the stage?
My lord, the petitioner as well as the opposite
Respondent
party is
Father and mother, my lord. Respondent number C is the husband. Respondent number 2 is the husband. My. May I please, your lordship? My lord, here in this case, the informant of the case is died in the meantime, and the parents are awaiting for the outcome of the case. This is a case under section 498
has already been submitted the final report. This case may be in
charge sheet submitted, cognizance was taken, but the trial is till now not a single witnesses has been examined. Nothing was only expedited trial. Died.
118 of 20.
Lordship may keep this matter after 2 weeks. My lord, the petitioner as well as the opposite party is
Father and mother, my lord. Respondent number C is the husband. Respondent number 2 is the husband. My. May I please, your lordship? My lord, here in this case, the informant of the case is died in the meantime, and the parents are awaiting for the outcome of the case. This is a case under section 498
has already been submitted the final report. This case may be in
charge sheet submitted, cognizance was taken, but the trial is till now not a single witnesses has been examined. Nothing was only expedited trial. Died.
118 of 20.
Section 20B to C NDPS.
Father and mother, my lord. Respondent number C is the husband. Respondent number 2 is the husband. My. May I please, your lordship? My lord, here in this case, the informant of the case is died in the meantime, and the parents are awaiting for the outcome of the case. This is a case under section 498
has already been submitted the final report. This case may be in
charge sheet submitted, cognizance was taken, but the trial is till now not a single witnesses has been examined. Nothing was only expedited trial. Died.
118 of 20.
Section 20B to C NDPS.
Father and mother, my lord. Respondent number C is the husband. Respondent number 2 is the husband. My. May I please, your lordship? My lord, here in this case, the informant of the case is died in the meantime, and the parents are awaiting for the outcome of the case. This is a case under section 498
has already been submitted the final report. This case may be in
charge sheet submitted, cognizance was taken, but the trial is till now not a single witnesses has been examined. Nothing was only expedited trial. Died.
118 of 20.
Section 20B to C NDPS.
May I please, madam? Here, the petitioner announced the defendants before your lordship. Now, the trial court partly decreed the suit, and the judgment is at page 45. Against that, the present opposite parties, they have preferred an appeal. That appeal is pending. Now, before the lower appellate court, under Annexure 3 at page 15, the first round application under Order 39 and 2 was filed for the first time. Your Lordship may see that order. Annexure 3, page 50. This is before the first appellate court. Who are you? I'm the defendant. You are the defendant's petitioner before your Lordship. Now, if your Lordship sees page Annexure 3, page 50, this is a copy of the order passed in IA number 10 of 2013 by the learned additional district judge. And this IA under Order 39 1 and 2 was dismissed. Now, the trial court thereafter, another IA in the same format, slight changes here and there, was filed under Annexure 4, page 55. That appeal is pending. Now, before the lower CMA number 3 of under Annexure 20 at page 15, the first round application under this is under 151. This is under 151 for the first time. Here, see that there was a similar prayer of injunction. Now, before the first, while entertaining this CMA, and the lower appellate petitioner appointed an advocate commission, and that is the order. If your Lordship sees page Annexure 3, page 50, no, not this is a copy of the order passed in IA number 10 of 2013 by the learned additional district judge. For this, they may exercise power under this IA under Order 39 1 and 2 was dismissed. But the question before your Lordship is that under these another IA, this order is completely unwarranted. Slight changes here and there. And in an appeal, has filed the report 4, page 50. No, this order has been stayed. There is an interim order of CMA number, and this is my Lordship for the first appellate. Where is that order? Annexure 1, page 11 is under 151 for the first time. Here, see that order. There was a similar prayer of injunction. Let the report come now before the first. While entertaining this CMA, first appellate court, lower appellate petitioner appointed an advocate commission. So the first appellate order, if your Lordship sees page unthinkable. Any no, not yes, passed in IA number 10 of maintenance. In that IA, there is no prayer for appointment of advocate. This IA under Order 39. May I just submit? There is no prayer by any of the parties to appoint advocate. Under these he makes out a order is completely unwarranted. And in an appeal, has filed the report 4, page 50. No, this order has been stayed. There is an interim order of CMA number, and this is my Lordship for the first appellate. Where is that order? Annexure 1, page 11 is under 150. Read what you want to say. There was a similar prayer of injunction. Now, before the first, while entertaining this CMA, first appellate court, 39 1 you are 39 1 2 is already unthinkable.
Only I am reading the page 11 my lord. While the appropriate petition was
in that IA, there is no prayer for appointment of this may I just submit? There is no prayer by any of the parties to appoint advocate. Under these he makes out a order is completely unwarranted. In an appeal, has filed the report 4, page 50. No, this order has been stayed. There is an interim order of CMA number, and this is my Lordship for the first appellate. Where is that order? Annexure 1, page 11 is under 150. Read what you want to say. There was a similar prayer of injunction. Now, before the first, while entertaining this first appellate court, 39 1 2 is you are 39 1 2 is dispute, I understand, but can you thinkable?
Only I am reading the page 11 my lord. While responding he was
there is no prayer for appointment of this
they have filed an
there is no prayer by any of the parties to appoint advocate. Under these makes out a order is completely
my prayer was touching my house. They have denied that there is no house. So they have filed so in view of the
39 want to dispute, I understand, but can you
That's not the only question in the maintenance.
Another my lord. My prayer was catching my house. And they have that is
This order has been stayed since 2020. This order has not been. Let the appeal be heard finally. That will resolve. It's their appeal. If they succeed, the lordship may target the appeal. There's absolutely nothing in this.
They have right to object. Again, objection, counter objection. What is the value of that? Again, no, this appeal will be delayed. You are unnecessarily delaying the appeal. Better you should get the. That is why how somehow it is delayed. Now what he says is that the ideal position today. Now let the appeal be heard. Appeal is 2008 appeal.
This order would not have pushed this had it been the trial court order. Here there is a judgment in which where the trial has happened. All these are the first appeal. This appeal is not to target the There's absolutely nothing in this.
They have right paragraph, which paragraph? Again, objection, counter objection. What is the value of that? Again, no, this appeal will be delayed. You are unnecessarily delaying the appeal. Yes, better you get the. What is the proposition? That is why how somehow it is delayed. Now what he says is that the ideal position today. Now let the appeal be heard. Appeal is 2008 appeal.
This order would not have pushed this had it been the trial court order. Here there is a judgment in which where the trial has happened. All these are the first appeal. This appeal is not to target the There's absolutely nothing in this.
They have right paragraph, which paragraph? Counter objection. Try to understand what is the objection. Objection is this appeal will be delayed. You are unnecessarily and 1 2 was rejected. There are the appeal is pending. In the appellate stage, you move an application under 151. That is why slightly changing the original application 39 1 2, and that is allowed. And appointment commission is appointed. That's what is the objection. The judgment will not help you.
This order would not have pushed this had it been the trial court order. Here there is a judgment in which where the trial has happened.
Don't repeat, madam. I understood it. No. Where is that application? 39 1 2 application.
Kindly see. First, rejection by the lower appellate court, Annexure 3, page 50.
55 0, yes.
50. And there are specific findings that we are in possession. And this order by the lower appellate court has attained final.
39 1 2 was rejected. There are the appeal is pending. In the appellate stage, you move an application appeal 151. Slightly changing the original application 39 1 2. That is allowed.
I'll show that
and appointment
page 51, paragraph 3. Heard both sides, peruse the entire case record. In the original suit, the gift deed so and so are under challenge. In such a situation, prima facie can be answered in favor of the appellant petitioner. However, it is the admitted case of the petitioner that the suit has state line. So any construction over the first rejection by the lower petitioner admitted that we have raised so and so. 55 So there are specific findings. Order 39 1 that we are in possession. After this another order by the lower has attained final. It's not maintainable. And while that IA is pending, he has appointed an advocate. That IA is also pending. So this kind of course,
slightly changing the original application.
I'll show that page 51. 1, paragraph. If Lordship wants, I can show one judgment. Heard both sides, peruse the entire judgment to the trial court, and then whatever you want to challenge in such a situation. Lordship wants, prima facie can be answered in favor of the appellant petitioner. However, if the admitted case of the petitioner that the suit volume 84, 1990 construction, page 7 first rejection by the lower petitioner admitted that OP have raised so and so. 55. So there are specific findings. Order 39(1) that we are in possession. After this another and the relevant portion would be the penultimate paragraph at page 780, last page, just above para 5. If I can take place just after the quotation. In the present case, though no survey knowing commissioner had been appointed in the trial court, and as such the question of rejecting or accepting the last page of the entire case just for paragraph that the issue has been answered in favor of the as such. However, while setting aside so and so, I direct volume 84, 1990 construction page 7. The relevant portion would be just above that. The lower appellate court should have considered the question of appointment of a survey knowing commissioner only after scanning the evidence, and if it would have considered that the evidence on record was not sufficient to dispose of the matter, then the question of appointing a survey knowing commissioner for the purpose of identification should have been quotation. In the present case, was the middle of no survey knowing commissioner. So this is the crux. This is almost like such a question of evidence or something. Order 41 will 27. Last page. At the time of hearing, if you need, let us see the just for paragraph. The decree, my lord, is answer in favor of the as such. Page 47 it begins, and it direct. Page 45 is the operative. 45, the relevant portion would be just above that. The lower appellate court should have considered the question of appointment of a survey knowing commissioner only after scanning the evidence, and thereafter considered that the evidence on record was not sufficient to dispose of the matter, then the question of appointing a survey knowing commissioner for the purpose of identification should have been quotation. In the present case, was the middle of no survey knowing commissioner. This is the crux. Nobody is almost like an advocate of evidence or something. Order 41 will 27. Last page. At the time of hearing, if you need, let us see the just for paragraph. The decree, my lord, is answer in favor of the as such. Related what? Page 47 it begins, and it direct. Page 45 is the operative. 45. The relevant portion will be just above that. The lower appellate court should have considered the question of appointment of a survey knowing commissioner only after scanning the evidence, and thereafter considered that the evidence on record was not sufficient to dispose of the matter, then the question of appointing a survey knowing commissioner for the purpose of identification should have been quotation.
Is in charge of settlement.
They have sold to other parties. If you need, already they have partly succeeded in the trial. Succeeded.
Let the appeal be related what? Let the appeal be heard.
47
I'll target the appeal.
and direct. Page 45.
Then there is no never ending 45. Just go on.
Let their appeal be heard.
Let the appeal be heard. Time bound direction I'll give. Let the appeal be heard.
This order has been stayed right from the inception.
Not adhering to your benefit, not his benefit. Let the appeal be heard and decided if they are not. I'll give a time bound that way. Because it is pending, the appeal is pending since there is charge of settlement when the appeal was filed. 2008, just imagine.
RFA number 35 of
2008.
If you need, pending. Already they have partly succeeded in the trial. Succeeded.
Let the appeal be heard. Let the appeal be heard. I'll target the appeal.
I'm grateful to you.
Then there is no never. This matter is also pending since just see imagine. Let the appeal be heard and time bound and stage operating. Time bound direction I'll give. Let the appeal be heard.
This order has been stayed right from the inception.
Not alluring to your benefit, not his benefit. Let the appeal be heard and decided to the other. I keep a time bound. Because it's pending, the appeal is pending since there is charge of settlement when the appeal was filed.
Filed by the company.
Just imagine.
RFC number 35
was later transferred to their daughter.
Pending.
Already the registered sale date number.
Let
The registered date number so and so.
Let the appeal
And the complaint is filed by the complainant.
there is no, this matter is also pending since just imagine.
Mother who is the husband.
Time bound and stage of time bound direction and
This order has been stayed right from the inception.
not alluring to your benefit, not his benefit. Let the appeal be heard and decided to the other. I keep a time bound. Because it's pending, the appeal is pending. You are a petitioner. What are you trying to tell?
Sir, my prayer is that as the property is recorded in the name of by registered sale by the registered number so and so will transfer to their daughter and the complaint is filed by the complaint is filed by the
pending since just imagine.
mother who is the husband.
Time bound and stage of time bound direction and
This order has
I do not know for whom he is appearing. He is appearing for petitioner. I am the petitioner.
Are you appearing for petitioner?
Maybe for the witnesses mentioned in the
What are you trying to tell?
complaint case.
Sir, my prayer is that
This is the causing the
as
problem.
the property is recorded in the name of
You are appearing for whom?
sir, I am applying for the advocate solution number so and so will transfer to their daughter.
Samyaswarup.
Samyaswarup was appearing for whom?
Yes, yes. Now I also understand. He is appearing for two witnesses who are alleged in this named in the complaint petition. The allegation is, your lordship, there are two sisters. Now one sister, the petitioner before your lordship, property is recorded in the name of witness number 2. I am placing the name, your lordship. Manorama Panda. Manorama Panda has it as her self-acquired property. She had sold it to my client for the witnesses. Now the other daughter comes that I have just gained her over and all that, and she is entitled to say is causing the problem. On the basis of that, he has falsified the right between two sisters. Now the Manorama Panda comes before your lordship, and as well as her husband, they have filed affidavit. No, we have sold it to our daughter, the present petitioner, who is looking after us. Who is notice to was appearing for? Yes, yes. Now I also understand. He is appearing for two witnesses who are alleged in the complaint. But in the complaint, the sisters were not possibly two sisters. Then they have so one sister, they have petitioner before. They have so much of fight. In order to support the case of the present, I am placing the name, Lord. Manorama Panda. That is another aspect. What is it as a self-acquired collecting evidence sold it to? No, that will also leave aside. Now coming back to the other daughter comes that I have property has been purchased, gained her over and all has been sold to the present petitioner by virtue of registered sale. Of that, he has falsified the right between two sisters. I have made now the Manorama Panda comes before you taken out notice as member of the complainant and sold to the other accused person, the present petitioner, who is looking after. And my lord, the property was duly authenticated and sold by my mother to me for two witnesses. That is there. So really, the case cannot survive. But in the complaint, the sisters were not possibly two sisters. What are the allegations? One sister, they have petitioner before. They have some of fight. In order to support the case of him and present petitioner, so the name is 10. Manorama Panda. That is another aspect. What is self-acquired collecting evidence sold it to? No, that will also leave aside. Now coming back to now the other daughter comes. My husband property has been purchased and her over and all that has been sold to the present petitioner who allegedly by virtue of registered sale. Of that, he has falsified
5 by 260 only. I have made now the accused number 1 of this peaceful or taken out notice in favor of the complainant and so also the other accused person. Complaint page with this and my lord, and property paragraph 3 is sold by my mother to me. The accused number 1 is the younger sister of the complainant, accused number 2 is the husband of the accused number 1 and brother-in-law of the complainant, whereas the accused number 3 is the district sub-register of Khordha at Bhubaneswar and employed in the trade office such and such. So the father of the complainant is a retired government servant who has been retired from his service and after completed his full tenure in service, during his tenure, he has created a property under Moja such and such in the name of the witness number 2. The said property which has been created in the name of witness no by the witness number 3 out of his income from the government service. The witness number 3 has lots of love and affection and care towards witness number 2 for which the father of the complainant, witness number 3 has created the property in the name of his wife, witness number 2 out of love, affection and care instead of purchasing sale in his name. These are all witnesses, sir, my lord, in the complainant case. The husband of reference number 1 and brother-in-law. The said property has been purchased by the father of the complainant, registered service in the name of witness number 2 in two phases and employed in his trade office such and such. To mention here that during the time the purchase and before and after the purchase, retired government servant who has been retired from his service by the father of the complainant, witness number 3, witness number 2, neither whereas they created a property under Moja such and such in the name of the witness number 2 are not here. The said property which has been created in the name of witness no by the witness number 3 out of his income from the government service. The cognizance number 3 has lots of love and affection and care towards witness number 2 for which the father of the complainant, witness number 3 has declared the property in the name of his wife, witness number 2 out of love and care instead of purchasing sale in his name. These are all witnesses, sir, my lord, in the complainant case. The husband of reference number 1 and brother-in-law. The said property is operated by the father of the complainant without knowing what are the and employed in his trade office such and such. Statement of during the time the purchase cognizance father of the complainant. And if you read the complaint, by the father of the complainant, witness number 2 that is very statement that is correct. And stage operating in the name of the witness number 1 here. The said property is there by the witness number 3 and it was listed earlier also before your lordship. Cognizance number 3 has lots of witness number 2 the father of the complainant, witness number 3 has declared the property in the name of his wife, witness number 2 out of love and care instead of purchasing September name. You have taken the witnesses, sir, my lord, in the complainant case. The husband of reference number 1 and brother-in-law. The said property is operated by the father of the complainant without knowing what are the solid up to week and rating. The statement of during the time the purchase cognizance father of the complainant. And if you read the complaint,
Praying for quashing of affair, my lord. Because the marriage has been solemnized on 27/5/2019.
sorry,
Marriage has been solemnized, my lord, on 27/5/2019. Praying for quashing of affair, residing in a single roof, my lord, blessed with a child. Because last marriage I have not able to submit the entire order 2019 that has been submitted, your lordship. Marriage has been solemnized, my lord, on 27/5/2019. Saying for person are residing in a single roof, my lord, blessed with a child. Because last marriage I have not able to submit the entire order 2019 that has been submitted, your lordship. Marriage has been solemnized, my lord, on 27/5/2019. Saying for person are residing in a single roof, my lord, blessed with a child. Because last marriage I have not able to submit the entire order 2019 that has been submitted, your lordship. Marriage that is not submitted, that is with 27/5/2019. And he is also present before the court. Notice was issued in a single roof, my lord. Yes, yes. Notice issued and they have filed a joint affidavit. Last occasion, but that is not some landed friends appearing for informant, and he is also present before the court. Notice was issued in a single roof, my lord. Yes, yes. Notice issued and they have filed a joint affidavit. In the order 600, my lord, but that is not some landed friends not yet received. Put upon 3/3/2025. Waiting for affidavit. What is the stage of notice issued and they have filed a joint affidavit. In the order 600,
that was the direction. 3/19/24, the state was supposed to get the
not yet received. Put upon 3/3/2025. Waiting for affidavit.
in a single group.
What is the stage of
notice issued and they have filed the
what is the stage of 390 or 24?
investigation
The state was
matter
supposed to
so
get
from
answer.
magistrate council matter to receive put up on 3 to investigation matter but
What is the stage of
issue and they have filed the
charge has been filed or not? What is the stage of 390 or 24? The state is supposed to get answer.
magistrate council matter to receive put up on 3 to investigation matter but
What is the stage of
issue and they have filed the
charge has been filed or not? What is the stage of 390 or 24? The state is supposed to get answer.
the husband is working a petitioner working out of the state matter but
What would you, there is no instruction.
one any
You are not able to tell
any
anything.
specific that's
What is the stage of sorry?
any specific date
The state is supposed to get answer.
the husband is working a petitioner working out of the state matter but
What would you, there is no instruction.
one any
You are not able to tell anything.
It's a case for quashing of the cognizance confidential proceeding arising out of a EPC agreement between the managing director and the contractor and FR has been registered by managing director with regard to the sanitary proceeding as per the arising out of the agreement between it was to be taken up managing director and the contractor that was my ground and the case was registered managing director with regard to my ground sanitary proceeding as per the arising out of the agreement between it was to be taken up managing director and the contractor negligent that was not made out. And the case was registered managing director with regard to my ground sanitary page number 20. Agreement between the present petitioner is the manager of one is the dash and the contract negligent. What is the stage on it? None of consequences has been taken and thereafter it was pending the petitioner is the manager of one is the dash and the contract negligent. What is the stage on it? None of consequences has been taken and thereafter it was pending the number 20. Their ground also that although there is
criminal cases are decided on the basis of pleading. You say something, he says something.
their ground also that only ground that there is this clause in the agreement, but the manager has to take care of it.
Criminal cases are decided on the basis of pleading. Let us see the evidence. You say something, he says something.
Their ground also that only ground that there is this clause in the agreement, but the manager has to take care of it.
Criminal cases are decided on the basis of pleading. Let us see the evidence. You say something, he says something.
Their ground also that only ground that there is this clause in the agreement, but the manager has to take care of it.
Criminal cases are decided on the basis of pleading. Let us see the evidence. You say something, he says something.
Their ground also that only ground that there is this clause in the agreement, but the manager has to take care of it.
Criminal cases are decided on the basis of pleading. Let us see the evidence. You say something, he says something.
Running page number 30. Bottom, second last.
During the investigation.
That is the running page number 30. Maintaining the bottom, second last.
During the investigation.
That is the running page number 30. Maintaining the bottom, second last. Rash and negligent is absent, my lord, which is the primary ingredient of
Then again, that's what I'm saying. You move an application and file argue and charge. If not 302 A, it is something else, maybe. The court will take the call.
My lord, 482 I have moved because prima facie is not made out, my lord.
No.
Your lordship may just
petitioner is
my lords may post it to some other day, my lords.
Huh?
My lords may post it to some other day.
Why? I'll give you that liberty better that
my lords, I'll find
I will record that you will move an application and trial court will decide this issue.
my lords, I'll come up with a judgment which
what? How can you dilute the 161 statement of
no, my lords, that is not what I'm
judgment?
contending to say, my lords, because on prima facie, if the case is not made out, my lords may be permitted to.
Is there any interim order?
My lords,
No,
Your Lordship may keep it to next week, my lord.
What next week?
My lord, sir,
I'm
I'll just
giving-
satisfy,
No.
or else your Lordship may decide
This
it on.
is a very bad way of practice. You argued, if the court is not there with you, you have an interim order, then don't.
No, my lord, on prima facie only. That is why.
That's what I am not satisfied. What you do is, I am giving you the liberty. I will not prejudice you. I'll give you liberty, move an application, argue all this point and seek for a discharge. If 304 A is not made out, something else may be made out. The court has to see the entire evidence before him. And thereafter they take the call. Cognizance, how can I quash the cognizance by reading the contract conditions? It is not form part of the charge sheet. If 304
There are
161 A is not made out, something else may be made out.
My lord, sir,
The court has to see the entire evidence
keep it
before him.
to next week, my
And
lord.
thereafter they take the call. Cognizance, how can
Now
I
I'm satisfied. I'm
quash the
there.
cognizance by reading
Till 4 o'clock I'm
the contract conditions?
My lord, I need to
It is
find
not
that
form
judgment
part of
with
the
charge
charge
sheet.
doing it, I'll tell you. If 304
My lord, may keep it to
161 A is
tomorrow.
not made out,
You
something
wasted
else
my
may be
20
made out.
minutes now. My lord, tomorrow your
Court has
Lordship
to
may
see
keep
the entire
Lordship
evidence
may keep it
before him.
to next week, my
And
lord.
thereafter they take the call.
Why not
Cognizance,
today?
how can
Now I'm
I
satisfied.
quash
My lord,
the
I'm not
get
even-
out of this by
My
reading
lord,
4 o'clock
I'm
contract
not available
conditions?
because I need to
It is
find
not
that
form
judgment
part of
with
the way
charge
of
sheet.
doing it, I'll tell you. If 304
My lord, may keep it to
161 A is not made out,
tomorrow.
something
You wasted
else
my
may be
20
made out.
minutes now. My lord, tomorrow your
Court has
Lordship
to
may
see
keep
the
it
entire
tomorrow.
evidence
Keep it
before him.
to
Creating
next
problem.
week, my
And
lord.
thereafter they take the call. 2018, how can I 2008, 2009 interim order. Completely non-application of mine.
My lord, will satisfy on that day.
Yes.
79.
May I plead your lordship? My lord, the OP number 2 lost a case against her former husband and father-in-law and mother-in-law under section 498A, 323, 294 and 43. Then obtain a thereafter, my lord, obtain it.
100. Let us see the service position.
Notice is sufficient, and will also last petition directed.
Sufficient. Nobody has entered a period.
No, my lord.
Notice,
my lord, all
notice on opposite party number 2 is sufficient. However, nobody has entered a charge sheet filed on.
Charge sheet has been filed, and beyond that, my lord, nothing. My lord, there were altogether 50 accused persons named in the charge sheet, and witnesses, probably half of the accused persons are dead, half of the witnesses will be dead. Your Lordship may kindly see paragraph 15.
15, huh?
Paragraph 15, my lord, page 19.
This is co-accused.
Yes, my lord. This, I start from the last sentence.
On the next.
In the context of right to speedy trial, my lord, got it? The last sentence. Paragraph 15, the last sentence.
Yes, yes.
In the context of the right to speedy trial, this court reminds that the criminal trial is a voyage of discovery in which the truth is the quest, but it is the duty of the presiding judge to explore every possibility to discover the truth to advance the cause of justice by providing speedy trial to the person accused of this offense, which is the course of fundamental right of the accused as guaranteed under Article 21 of the Constitution of India. It is, however, true that if the system is unable to, that below, my lord, in this case, it is also not in dispute that the petitioner was discharged of the offences under the PC Act. My lord, over here, it's slightly different because in that case, my lord, the co-accused was discharged under the PC Act because for want of sanction.
This Nandakishore Pal is one of the co-accused in
Co-accused, my lord. He was also an engineer. This present petitioner was also an engineer.
Yes.
But my entire career has been jeopardized.
Who is appearing for vigilance?
The vigilance department on the last date, Maharana.
Mr. Maharana is not well.
But somebody should have been there, my lord. But
Nobody is there. Nobody is there.
Purely on the ground of delay, only this case has been quashed. So why should, my lord, I stand in the same 93, my lord. And Vakil Singh, Honorable Supreme Court has also said that judgment has also been followed in this case. Vakil Prasad Singh, my lord.
97 the charge sheet.
97 charge sheet. And half of the accused persons, 50 altogether, along with villagers, my lord, and the government officials, 50 accused persons, half of them are dead. The witnesses are dead. So why this?
This is a futile exercise.
My lord?
This would be a futile exercise.
Absolutely, my lord. But I have been denied of my promotion. My entire career has been jeopardized. Now I've retired also. I still run around the court, my lord.
What to do? You have to give a copy to him. And,
I have given already, but I had given a copy to Maharana.
None here. That is Mr. Rao and counsel for the petitioner submits that in the similar fitting the co-accused revision petition, no? Revision. A revision petition against the charge has been allowed and the co-accused has been allowed by the coordinate bench. They know particular in source of
Lordship, I keep the judgment, my lord.
Which is parity with the since NDPS of England is the matter. It's already before. Not like we are. Total is 90 or nothing. Yes.
This matter
Yes,
I
sir.
am for the complainant, madam. Opposite party number
I am
2.
appearing, my lord. I am appearing, my lord. My lord, may I kindly see my lord's last order while issuing notice on 11/11/2024.
I have a small prayer.
Yes.
That my lord, I have to get some documents. It is forming part of the complaint petition. It is in the LCR also. Either if your lordship would be kind enough to call for LCR, I have to get from my party that when the check was presented before the bank, because their case is that no date is pleaded in the complaint petition. But voucher, when it was presented, that forms part of the complaint petition. It is mentioned. But the physical corpus of that document, my lord, is not available in my file. If your lordship would kindly consider the LCR may be called for, or I would get it from my party, my lord. That is required. That would give an ending of the matter, my lord. Because your lordship knows, my lord,
There is no application for condonation relate
that all the things I would get, my lord.
Okay. Mr. Das, learned counsel for the opposite party number 2 submits that he would be filing the relevant documents to substantiate the claim.
Pertinent question.
2 weeks time is granted.
Pertinent question is whether they have complied 142 proviso or not.
2 weeks time is granted. Okay. Please the matter on the interim or to continue. 83.
Item 83 prefer an adjournment.
On request adjournment. Yes.
Date.
84.
May I please yours? My lordship, I pray for short time, my lordship, that today the client is instructed me to his desire to engage the senior counsel, my lordship.
My lord, I don't have any problem, my lord, if your lordship is adjourning the matter. But what happened, my lord, due to the pendence of the case, my lord, the trial is now held. Although no order has been passed. But every time, my lord, they are saying that, my lord, an application is pending. So my only clarification is required, my lord. Pendence of this application is not a bar, my lord, to.
Counsel for the petitioner seeks an adjournment on the personal ground. This matter is has been urgent time to time. Mr. Naik submits that in the pretext of pendency of this petition, trial court is not proceeding with the matter. It is made clear that there is no interim order passed with this matter. So it's interim order passed in this matter. Please the matter after court. I have said that no interim order is passed.
No interim order passed.
I have clarified it.
They are saying that 482 application is pending. That is the
I have clarified it. Time to time it is urgent. No interim order is there.
It is not a bar mirror to proceed there.
Therefore, there is no bar for the trial court to proceed with my application. 85 months.
One, one, on behalf of Mr. Jetty, my lord, he is appearing in another case and I am for one case. For question.
Here, my lord, injured are not made party, my lord. Though compromise, my lord, only informant made party. Injured were not made party.
Injured, in both the cases, they filed the injured and injured is the petitioner in one case. In one case.
No,
In other case also injured is there.
In first case, injured is K. Sundar Rao. In second case, there are 3 injured. And only informant made party.
Well, she will say you can, but all the injured person.
Petitioner is granted leave to implead the injured in the case as opposite party. We should notice to the opposite party.
There is no need of issuing notice, my lord. We will appear because the injured persons.
Formal notice will go. You file local.
Yes, my lord. You will also fix a short date, my lord. Next week you will also fix. Oblige, my lord.
26.
Yes, my lord. In a 144 proceeding, the learned executive magistrate has passed an order what can only be passed by in a civil case, civil suit. And that has been confirmed by the session judge.
Yes.
I have appeared for the opinion number 1 yesterday, but my name does not appear in the list. Later, I have not no brief.
Don't to have already appeared appearance for opposite party, but his name is not being reflected in the service. He submits a copy. You have a copy of the petition?
Yes, copy.
Next week.
Oh,
My lord, next week.
87. 27 January, your lordship took cognizance of the case. At a particular place, Vidyadarpur village, someone died of electrocution, my lord. The local of that area and the relatives of the deceased blocked the road and resorted to agitation. Ultimately, the blockade was lifted after 3 hours. That's the case of the police. Case has been instituted by the police. I was going through Nata because my construction is going on beyond that area. I have been made an accused. I do not belong to that place. I am not related to that person who died.
All the statement, my lord, said the present petition of name, my lord. Jobrar Sheikh Mujbil Haq. Every police personnel, along with the local person, have said, stated the name of the petitioner.
Chandni Chowk, my house is at Chandni Chowk. I have given the address. And my construction is going on. I am undertaking.
All the statement, my lord.
I am undertaking 2 buildings there, my lord. So I have to cross from that area, my lord. I am stuck in the education, my lord. What can be done? And what are the offenses? 147, 148, 330, 294.
353, 353.
353, 350. Who abused? They do not say. Agitators abuse them in filthy language. There has to be a specific allegation. If I have abused somebody, you have to say, yes, Mr. Haq has abused me in this language. Agitators abuse. Who is the agitator, my lord? There are
how many accused are there?
40, 50 accused persons.
There are named, my lord.
And if Lordship says all the accused persons belong to that area, I am the only person exception. I belong to Chandni Chowk. But will they hire my service for this? Normally,
nobody knows you might have gone.
Not I'll be hired from Chandni Chowk and go and sit there in meditation.
File a status report. What is happening?
The accused are not cooperating, my lord. Kindly, the order sheet is also, my lord.
Whether he is cooperating or not.
My lord.
I'm not concerned.
None of the accused are present, my lord. The order sheet has been filed. Entire order sheet.
I have 41A has been issued.
73, till 74. Order dated 4/9/24, your lordship may say accused are absent. 5/4/24, accused are absent. They are not cooperating.
It's not there. Where is that? Where are you reading from?
The page itself, my lord, the order sheet is annexed, my lord. Your lordship may see, starting from page 70, 71, 72, 73, 74.
You may record this, my lord. On 17/2/2025, I have appeared.
You file a status report. What exactly?
My lord.
The State Council is to file a status report. Let us see.
88.
In these kind of cases, you will get nothing.
My lord.
And it continue to be a stigma, my lord, with this affair.
But you know, nothing happens.
Nothing to do with
101% acquittal. It is only burden.
all the cases return hostile, my lord.
Burden on the court, that's all.
Here, my lord, all the witnesses are police officer. Maximum. Police officer would have a witness.
And he has been paid compensation. One who died of electrocution, he has been paid compensation by.
Police को गाली दो रास्ता रोक को ले police को गाली दे. That is the case, my lord.
In a democratic setup, everybody has a right to protest.
And normally this happens, my lord. Whenever there is an accident, this happens.
Yeah, do they have any role in the electrocution? Nothing.
My lord.
Do they have any role?
No.
Then
Police are abused, my lord, for that reason, my lord. The prosecution is police are abused. Police is the informant.
that is the reason the vengeance. If it would have happened to the normal public, police would not have bothered. It is ego. So include everybody and file a charge. Merely because police are abused. Yes.
May I please? 88 and 89, both are arising out of the family dispute. The informant, they were the belonging to the
service. The opposite party too. Nobody, anybody is appealing?
I'm appealing.
Oh, so you are.
Appeal number 2, my lord. In both the cases. 88 and 89.
You want to interpret? So let's have appearance on behalf of party number 2. High Court of Orissa. Yes. Would you like to file any reply or argue?
Ready to argue.
Yes. Yes.
Mayor. One of the petitioners is the advocate of this bar, and his family member has been entangled in the instant case, or the behest of the informant. 2 cases have been in. The informant family, they are belonging to the police personnel. One is the DSP inspector. That is altogether separate story. Why not? There is a dispute arose regarding the boundary. What is the allegation, my lord? On last occasion, my lord, I have submitted before a lordship. Allegation that they have found that the present petitioner pouring some poisonous in the oil, for which there was a dispute. On last occasion, I have submitted before a lordship, while the charge sheet has been submitted, because they are the police personnel. Because truth will come out, for that reason, the water which is belonging to the oil has not been sent for chemical examination. But they have submitted the charge sheet that I have poured some materials in the oil. We have suspected that might have been poison. We have lost the FIR because they have assaulted. The police person did not accept the same. Even though accepting for a moment, what is the allegation? We have put some poisonous substance in the oil. That is the crux of the case. During course of submission of charge sheet, after investigation, because they are belonging to the police personnel, they know that if that could have been done, then real true state of FIR will come out. Without examining that waters, the substances, they have submitted the charge sheet saying so that 277, 506 and other factors. Yes. On last occasion, your lordship rightly put a question to the state council. Where is the chemical examination report? Nothing, my lord. That is the whole.
What are the offences?
Offences in past case, my lord, that is 277, 516, 294, 34 IPC.
Yes.
I have annexed the FIR along with the charge sheet, all the things. Second thing, my lord, second FIR, same family member, 284, 307. What is the 307? We are suspecting that they have put some poisonous thing in the oil.
Let us see the first FIR.
My lord.
First FIR is the first item, huh?
My lord.
Yes.
Same cycle style FIR. आम घर पछपटे आम कुआरे रही गत एत तारिख राति प्राय कुआरे पाखे पड़ोशी मलय दास और पुओ देवाशीष देवाशीष इज द प्रैक्टिशनर ऑफ दिस ऑनरेबल कोर्ट उभय आसी दानादार विष प्राय केते किलो पकाई देइछंती
Yes. When is the second FIR?
Second FIR, same thing, my lord. That is 89, my lord.
This first one is registered on when?
First one is, my lord, date 30th 9 2015.
Second one is.
First is 29, 2015, second one.
What is happening here now?
Well,
What is the stage?
Well,
What is the stage?
stage after submission of charge sheet, cognizance has been taken. I have challenged that cognizance, and so also issuance of process, and that case is pending.
2015. Yes.
After 10 years of the occurrence took place in 2016. Cognizance taken in 2016. Not only that, my family members are police personnel. This submission is not correct, what my learned friend submitted. The crops of the matter is not brought into the notice of the court. What happened in this case? We three persons, three families purchased 3 plots altogether simultaneously. 3 plots are there. My plot is in between, and my 2 sides, 2 brothers are there. Not only this affair, other affairs are also there from 2011 to 2021. In case of 277, 307 is also there. It is very difficult in the part of the investigating agency to file a charge sheet under section 307. If any police person is family member of the police person is there, they can do whatever thing they want. There's no investigation. And 2016 taking cognizance, they challenged after 10 years of the occurrence. And they threatened me that you sold this plot to us. So that is the only crops of the matter. Always, not only put poison in my well, they fire my motorcycle, fire my 4-wheeler, broken the wall. That also be false. And if putting poison in the well is false, then all the affairs laws against them is also false. Fire is also false. I put fire in my motorcycle. So if the police person, my family member, is one constable traffic, they can't छोटे मोटे post में चाकरी करती हो रहे. Very small, not DSP like this. Even if a family member is a police person, then whatever they want, they book any person in any offense.
They
And
are,
the main
they are the lawyer, you are the police.
Madam?
You are the police person
No,
in between. 2 lawyers are flanked.
My
It's bound to happen.
My friend is submitted. That is the reason this
Is there any chance of settlement? Why don't you settle? Because you are paying. All 3 of
I
you.
don't want to solve my property. That's the only.
All 3 of you are staying in the same place.
Yes.
Okay. And every day instead of fighting, why don't you settle? You settle.
But only subject matter of these cases are that they want to purchase my plot. I am an old man, I'm a senior citizen. My married daughter might have been working in a traffic office, some very clerical post. That he brought into here, that due to this reason, I file a affair time and again, and police submitted charge sheet. This is not a.
That may not be correct. That may not be correct. But I am sending you to High Court Mediation Center. So all the dispute, whatever dispute you have, you try and sort it out, because all you are staying in
Same
place.
vicinity, my lord.
Same vicinity.
We purchase the 3 plots at a time with all together.
You
I am
must
the
be,
middle portion, and my 2 brothers are there.
earlier you must be friend. They are friend.
From the very beginning, they want to purchase my plot. That is the only problem. My friend also know what is the dispute of arising between these 2 families. He knows, my lord. I know, he knows also.
Okay.
This is the crops of the dispute.
Regarding that to the nature of dispute between the parties, the fact that one of the parties is a lawyer and the other one is working in the police department, I think it is appropriate to refer the matter to High Court Mediation Center and the authority for the yes.
Both the matter, my lord. Interim order is there.
Interim.
Oblige.
88, 89.
88, 89.
Settle the dispute.
I have no role to play at all, my lord.
Settle the dispute, whatever FIRs are there, they come and I'll watch it.
But the only matter is, you also know what is the dispute behind this, all the affairs and problems. Only one issue.
They want that you should sell it and go.
He knows. What is the dispute? What reason he knows? I also know. This is the fact.
If they want to purchase, then sell it in a very higher price.
Then dispute is going on.
Higher price and goes purchase somewhere else.
ଏମିତି ଯଦି ଧମକି ଖାଲି ଯୋଉ ଘର ନେଇଯିବେ ଡେଲି ବାଡେଇବେ ମୋ ପାଚିରି ଭାଙ୍ଗିଦେବେ ମୋ ଗାଡି ପୋଡିଦେବେ ମୁଁ ସମସ୍ତେ କେହି ଦୁନିଆ ରହିପାରିବନି।
Try once. Let us see.
Complaint.
90 these two matters here also arise out of 138 proceeding where my lord application
Service complete.
311 application was rejected. Without hearing the other side, your lordship refused to interfere at that stage. So notices have been taken out.
You want to examine whom?
I have given the
complainant.
I have given even the questionnaire attached to the petition, my lord. Running at page 9 and 10.
Sir, are you opposing?
No. No, he is with me. He is opposing.
Are you opposing? Are you opposing? I understand. Are you opposing? You're not opposing. What on? Instead of wasting time, go and he'll cross-examine. There are a couple of questions he'll put. 138 matter by unnecessary. He's a rebuttable presumption. He has the right to lead evidence to discharge his burden. Why to delay it?
काली अच्छी प्रोसीडिंग टा पुणी से गला थरो भी 20 तारीख थला 22 रो पोस्टिंग
I'll say it will go on for another 10 years. Better I should allow and give one opportunity to him, and tomorrow he'll appear and cross-examine and finish it.
No, this after that only the petition has been rejected. Nothing has happened thereafter.
What do you say?
I am not ready.
He's not ready. What?
काली सर अच्छी प्रोसीडिंग टा
You application manage.
well lordship may award some cost and all that.
I'll put him to time. What is the check amount?
Check amount 20 lakh. 22.
There are two matters.
Two matters.
I'll impose some cost on him to be paid to you. What do you say?
22 gote. Arada kete?
22.
25.
He's not prepared. I'll put it tomorrow. Let him come. Tomorrow, huh?
Tomorrow sir thati achi kon ko.
Tomorrow, therefore I'm putting it tomorrow. Yes. Tomorrow.
98, 91.
Tale top of the list rakho.
Yes.
This is a vigilance appeal matter. I've prepared a short note. Just the dates.
Mr. Das, ready?
Partly ready.
Once he says that it comes.
Let us place the case.
No,
Your lordship will remember for a decade. So later.
I see the burden. You shift the burden on me. I'll hear the matter and reserve the judgment. See how many judgments are reserved. Rather, I'll utilize the time. I'll go and dictate some order.
This is a trap case. 5 witnesses have been examined. All have supported the prosecution case, corroborated each other. This is the case. So later place the points on her behalf. I will place the materials available on behalf of the prosecution.
I'll keep it on 5th. Get ready.
My lord.
5th, I'll dispose it. I'll come with not half preparation, full preparation.
Trap case.
5th, I'll finish.
How record?
5th, you come and I'll finish it up.
My lord, item number 103.